quickly before you, yeah, that's okay, they can start, that's.
Okay.
This is for the last item? for the
Yes, it
public
is.
hearing?
Yep.
We need to start?
Yes.
That for that
We're
simple
good.
reason?
Yep.
Okay, thank you.
Yes.
All set?
We're ready to go.
Good evening. I'll call to order this September 2nd, 2025 Fairfield Plan and Zoning Commission special meeting. Start with our meeting minutes from August 12th, August 26th. I have a motion on the item. Mr. Harrison,
We'll make a motion to approve the minutes from August 12th and 26th.
for a second. Commissioner Corsillo seconds. Commissioner Harrison,
They look good to me.
Commissioner Corsillo.
Further.
Is Commissioner Ford online? Start with that.
Or yes,
Is everybody up to speed on the minutes?
yes. And it's, Commissioner Collins is here too.
Okay. Do we have everybody then?
Mhm.
We have everybody. Commissioner Ford, you good with voting on the minutes?
Yes,
Any comments or questions from the commission?
none.
Put this to a vote. Mr. Harrison? Oh, sorry. All those in favor, please say aye or raise your hand.
Aye.
See 7 hands, so it passes, they pass unanimously. A lot of old business to go through. I'll call the first 2 items in old business related to 1477 Congress Street. Application of 1477 Congress Street to establish a new section 5.4. And zone change application of 1477 Congress Street LLC to establish a Congress Street Affordable Housing District. We have staff comments that have not gone through yet, because we've just been kind of tabling this item. Can we move forward with discussing this substantively tonight? Yeah, why don't we let's do a staff comment, because you haven't done your staff comments yet. Ms. Harrigan, why don't we give staff comments, we'll get a motion and see where this goes.
Do I need the mic? Are we okay? Okay.
Thank you.
Emmeline Harrigan, Planning Director for the record. 1477 Congress Street, the proposed 830G affordable housing project for this site includes a zoning regulation amendment and a zone change application with only a companion conceptual site plan. The zone change simply complements the applicant's proposed zoning regulation request for the subject parcel by changing the zone. It should be noted that adjacent neighbors have submitted a protest petition that otherwise meets the requirement of state statute. But Attorney Bellis questioned the legality of the submittal per the Branford Housing Authority case decided by Judge Berger that indicates that a protest petition cannot be submitted for an 830G application. However, the level of decision has been questioned as a Superior Court case and not an appellate or Supreme Court case that would determine overriding case law. This may not be a consideration depending on the final vote by the commission, but may need to be discussed. The commission will need to act on these items collectively depending on its deliberation and findings. Please note that should these regulations be adopted by the commission or by other means, that these will be section 3.8 of the reorganized zoning regulations in effect as of September 6, 2025, with all sections reordered accordingly. For the zoning regulation amendments, for the proposed Congress Affordable Housing District, amendments are specific to the proposed development site as it specifically references 1477 Congress Street and proposed section 5.4. Section 5.4.1 establishes the purpose and intent for the CAHD zone and provides definitions consistent with Connecticut General Statute 8-30G. However, in section 5.4.2, requirements as to planned affordable housing units, staff recommends striking the sentence within subsection B as follows. B, a planned affordable housing unit shall be occupied only as the purchaser's or tenant's primary residence. The applicant had included a section that that provided specific requirements for subletting an affordable unit, and that is not permitted. So we're, should you see fit to approve this application, we're requesting that that portion be stricken out. It's inconsistent with the applicant's own submitted affordability plan, and we don't believe that it's consistent with 830G. The incomes for the residents within the affordable housing units must be annually reported by the property owner every January 1st with a report to the Town Plan and Zoning Department, which confirms that that actual occupant is compliant with the area median income criteria and the affordable housing plan. So the affordable housing plan. So again, subletting of the affordable units is therefore not permitted. Within subsection C, staff recommends the following changes. It reads as follows: the developer or its successor may change the designation of which units within the development shall be set aside as affordable, provided that the minimum 30% set aside shall be maintained, and the development as a whole shall continue to comply with the paragraphs of this section. Staff recommends adding, as well as the general equal distribution of units by location and size, as referenced in the affordability plan recorded on the land records. Oftentimes what might happen is a resident of the affordable unit may get a higher paying job and then no longer be eligible for that affordable unit. Oftentimes the next unit that is comparable to that one will then be made available to someone who meets those affordability criteria. So we want to make sure that that's reflected so that the units are equally distributed. Section 5.4.5 provides the structure standards. TPZ staff recommends the following changes should modifications to the building be necessary. There shall not be any building or structure erected, altered, occupied, or used, arranged, or designed to be used within this AHD for other than subsection A, a building, adding the words not to exceed, and striking out with a total of 39 residential units, gym, lobby, utility area, leasing, office, and recreation room. Subsection B, striking out the words each floor shall have 5 floors above the garage, and instead substituting the building shall not exceed 5 floors above a garage level. Subsection C, parking shall not exceed 49 spaces for 49, and striking out for 49 motor vehicles. As this section was very specifically prescriptive, and this is not a building this is a very conceptual site plan. Should they get to inland wetlands, they would have to come back with new zoning regulations. Should the building be altered in any way, shape, or form, because it provides an absolute instead of an upper threshold. So it seemed that the regulation should allow for building modification, should that be appropriate to meet inland wetlands requirements, building code requirements, which are not fully vetted by this conceptual site plan. Section 5.4.7 provides a zoning table of bulk requirements. The standards provided largely mirror the building frontage and setback criteria with changes to the number of stories. The minimum floor area requirements for residential buildings are no longer permitted by state statute and are suggested to be stricken from this section. However, it should be noted that Fairfield's current zoning regulations are deferential and take into consideration the proximity of sensitive environmental features that may be adversely impacted by development, such as wetlands, watercourses, conservation easements, rivers, ponds, lakes, or marshes in two distinct ways: by reducing proportionally the available lot coverage for development. First, the minimum square requirement of 200 feet is exclusive of wetlands and watercourses. And secondly, the lot coverage calculation must be exclusive of these environmentally sensitive areas as well. The applicant's proposed regulations fail to do the same. The subject parcel would not meet the first lot square criteria due to the wetlands located on the subject site that extend onto the town parcel, and it may not meet the 10% lot coverage limit estimated about 12,250 square feet for the proposed apartment building and 1,300 square feet for the existing house. Rough estimate of the current lot of 81,728 square feet is likely reduced by about the 18,450 square feet of wetlands, which would allow for only about 6,429 square feet of lot coverage. So that's just something to consider within the regulations. Similarly, with the maximum height of the building provided, I think that the commission, should they again choose to approve this, or if it's approved by any other means, that there should be not to exceed language within both the maximum height of 40 feet and the maximum number of stories of five stories. Should the project require future revisions, section 5.4.9, parking should also be revised, that there shall be a maximum of 49 parking spaces on the property as well, not a prescriptive, there shall absolutely be 49 spaces. It should also be noted that the applicant's conceptual plan, P 2.0, prepared by J. Edwards Associates, dated August 8th, 2024, does not presently meet the proposed CAHD regulations of 10% lot coverage and 15% floor area, and shows 17.5% lot coverage and 54.5% floor area respectively. For the conceptual site plan considerations, the applicant has provided a conceptual site plan, an elevation, a first floor plan, and representative floor plan for the proposed 39-unit residential building with 49 parking spaces located below and on a parking lot adjacent to the building. The existing single-family house, constructed in 1834, is proposed to remain in its existing location, with the apartment building constructed to the side and the rear of the house. And then if you want to refer to the zoning regulation analysis for the conceptual plan and consistencies with the proposed regulation, I think their conceptual site plan would require some level of revision because it doesn't appear to be consistent with the regulations that they're proposing. The applicant has expressed their opinion that section 8-30G subsection 7 minimally requires a concept site plan as follows. A commission by regulation may require that an affordable housing application that petitions for a rezoning of the property that is the subject of the application shall be accompanied by a conceptual site plan. Any such regulation, however, shall not require the submission of the type of plans, studies, calculations, or similar detailed information that will otherwise be required in connection with site development, subdivision, or re-subdivision plans, which, when approved, will serve as the basis for the issuance of a building permit. The general statute does not otherwise adequately define what should be included in a concept site plan, but Attorney Bellis has indicated that his application meets the criteria for that requirement. The commission has to decide whether the plans provide a clear enough concept of the proposed regulations per the review criteria set forth both in 830G and the case law that is followed. The chasm between the level of detail for adequate site plan review and the basis for the issuance of a building permit is wide. For example, the commission has recently reviewed and approved a 254-unit building at 81 Black Rock Turnpike, a building 6 times the density as the requested zoning regulation and zone change proposal. The plan successfully submitted to the TPZ Commission for the recently approved 254-unit mixed-use building at 81 Black Rock Turnpike included 20 pages of architectural plans, 11 pages of site plans, 3 sheets of landscape plans with details, a lighting plan, and overall site plan, equaling 36 sheets total. The recent building permit application for this project, submitted on August 21st, 2025 to the Fairfield Building Department, includes 10 sheets for site plan information, 14 sheets of landscape plans, including irrigation and electrical, 42 sheets for building electrical plans, 18 sheets for fire protection, 22 sheets for plumbing, 22 sheets for mechanical, 51 sheets for structural, 202 sheets for full architectural plans for each floor, unit plan, fixture, window, and door details, and 1 site survey equaling 382 pages. The commission has to determine whether there is sufficient evidence in the record to make its decision. It's staff's opinion that the non-certified 4 pages submitted for the 39-unit project is inadequate to evaluate the project proposal requested by the zoning regulation amendment for the Congress Affordable Housing District. The applicant's experts have indicated that the existing 8-inch sewer pipe in the area has capacity to connect into the proposed 39-unit development based on anticipated flow. It should be noted that request for review to connect to the town sewer has not yet been submitted to the WPCA, and the nearest sewer line is located on Black Rock Turnpike, approximately 950 feet away. The applicant has not provided an alternative community septic design that shows adequate wastewater management for a project within the proposed CAHD regulation. And a project within this proposed CAHD regulation does not appear to contemplate this alternative as an optional wastewater system. Public water is available for the property, and the applicant has submitted an application to Aquarian to connect. A stormwater system has not been designed for this conceptual plan. The applicant's traffic consultant has determined that the proposed traffic volume generation, 17 trips during peak morning and 21 trips in peak afternoon, does not negatively impact traffic congestion on Congress Street. However, satisfactory sightline information has not yet been submitted. Per the town's engineering department, adequate driveway sightline analysis is conducted with 85th percentile speeds and not simply with posted speed limits. The police department has reported evidence of roadway speeds on Congress Street that exceed the posted speed limit at 40 miles per hour. The project's constrained site design does not provide adequate access for delivery or emergency service vehicles. The other two things to consider for this site, because the proposed regulation does specifically indicate that these regulations are only for 1477 Congress Street, is both the inland wetlands and the adjacent town of Fairfield open space and the FEMA floodplain considerations. The applicant's concept plan indicates that the site contains inland wetlands, but there is not a soil scientist report that accompanies this information. Upon the commission's request, the town's conservation department and the conservation director, Tim Bishop, a certified environmental professional wetland scientist, and a certified ecologist, has personally inspected the subject property that is tied to the proposed regulations. He has confirmed the presence of on-site wetlands on the subject parcel and extensive off-site wetlands on the adjacent town of Fairfield open space parcel. Mr. Bishop expressed concerns to the continued health of the Fairfield open space parcel. Mr. Bishop expressed concerns to the continued health of the wetlands due to the proposed project size implied by the proposed regulations and a lack of information on adequate stormwater management analysis and stormwater management plan, or a landscape or mitigation planting plan to protect the adjacent wetlands. Mr. Bishop also cites the location and increase of impervious surfaces adjacent to the inland wetlands and watercourses may have impacts that are also unclear due to the lack of information provided. Per section 22A-36 of the Connecticut General Statutes, the inland wetlands and watercourses of the state of Connecticut are an indispensable and irreplaceable but fragile natural resource with which the citizens of the state have been endowed, for which the state statute indicates that appropriate protections should be implemented to prevent undue harm. The applicant has not provided sufficient information to confirm that proposed regulations that suggest a future project design's close proximity to the wetlands does not cause undue harm to a resource otherwise protected by state statute. For the floodplain considerations, as the proposed CAHD regulations specifically pertains to 1477 Congress Street, it should be noted that the project site is located in the AE flood zone at an elevation of 99.6. The finished floor reference on the applicant's conceptual plan sheet 2.0 prepared by J. Edwards Associates dated August 8th, 2024 indicates a finished floor plan of elevation 101. An overall grading plan with finished grades for the proposed parking area or other site development areas has not been provided. The garage finished floors suggest filling in the FEMA floodplain, which is prohibited by state statute 8-21 that requires, and the language of the statute is shall provide equal conveyance and compensatory storage in non-tidally influenced floodplains. This restriction is also within the town of Fairfield zoning regulations flood protection section, current section 32.3F and G, pending section 20.2.3F and G for the reorganized zoning regulations effective September 6, 2025. The statute specifically identifies that non-tidal flooding environments have to meet these standards as freshwater flood sources are usually channelized, which means that their capacity and flow is limited by that channel and topography. Filling in one area directly displaces floodwater to adjacent areas either upstream, downstream, or on either side of the floodplain and directly impacts. This directly negatively impacts adjacent properties by displacing flooding onto other sites. For the town's flood protections regulations, a zero rise analysis needs to be completed by an engineer to show that any project proposal does not increase flood height on the subject site or other site. The applicant has not proven that their proposed concept site plan does not alleviate an anticipated increase in flooding harm, and the proposed CAHD regulations do not specify the requirement to do so. It should be noted that the building code includes flood design requirements for the structure similar to those in the zoning regulations, and those standards would be captured by a building permit application, but not the site-specific flood management criteria to first do no harm to other properties. During public comment, residents expressed concerns about the project's visibility, height, and increased trips and traffic generation and potential impacts to the adjacent wetlands. Attorney Green spoke on behalf of the Greenfield Hill Improvement Society, providing experts regarding potential negative impacts of the proposed regulations due to the size of the project, potential flooding impacts, lack of stormwater management proposed to the adjacent wetlands and natural resources on the adjacent town-owned open space. Attorney Green also spoke representing the Merritt Parkway Conservancy, with several historic resource experts specifically citing negative visibility impacts and irreparable harm to the park-like setting of the National Register designated parkway caused by the proposed regulations due to the resulting project's height and mass envelope and its high visibility at this low spot, given the site's close adjacency to the parkway. Per the Beach Road decision, the standard considerations for denial of a regulation amendment for an affordable project per the 830G statutes are: burden shall be on the commission to prove that the decision is based on sufficient evidence in the record. The decision is necessary to protect a public interest in health, safety, or other matters within the commission's jurisdiction. Such interests clearly outweigh the need for affordable housing, and such public interests cannot be protected by reasonable changes to the proposed development. Court cases have indicated that the record must establish more than a mere possibility of harm to a substantial public interest. The record must contain evidence as to a quantifiable probability that a specific harm will result if the application is granted. Mere concerns alone do not amount to sufficient evidence to support the denial of an affordable housing application. That's all I have.
Thank you. This is a difficult one.
Yeah.
Thank you for the very thorough analysis on your end.
Sorry about being so lengthy.
No, that's it's easily triple what you normally do, so thank you very much for that.
Yeah.
Right. May I have a motion on the item? Commissioner, whoever went first, I don't care. Commissioner Levy.
Yeah, I'll start with a simple motion and then we'll
Let's start
take
with-
argument.
Yeah, let's see where you go with the boy.
I would move to approve the text amendment, but subject to the condition which the applicant has agreed to, that any site plan submitted for any development that is not in conformance with existing, pre-amendment, regulations. In other words, he could still build a single family house here without coming back, but any other site plan which doesn't meet the existing regulations would still be subject to review on a de novo basis in accordance with the provisions of 830G, which would mean that many of these concerns would be addressed in connection with a site plan, which would have far more detail than the existing proposed conceptual plan. And in addition to that amendment, which again reserves the review subject to 830G of any site plan, It should be specifically understood through this text amendment that it leaves open the issue of the protest petition and the environmental concerns.
Can I, are you including,
I don't think the last two need to be part of the amendment per se. That could be just by way of argument.
okay, but how about, staff had some
And
suggestions?
also all of the staff
Yeah, that's fine.
comments as pointed out by Ms. Harrigan.
Okay. Is there a second to that? Commissioner Randolph seconds.
Move a second.
Okay. So a motion is to approve regulation amendment, the proposed, what are we doing?
Text amendment.
The proposed text amendment and the new district, subject to staff's suggested amendments to the regulations, but also what the a new provision that would say any application under these regulations, not our current ones, but under these regulations and district would be subject to the standards of 830G, what we just went over, the health, well, substantial harm, health, wealth, and safety. Okay. Everybody,
I need to have that clarified. I don't understand what the motion to approve.
so again, the motion, let me say it one more time, and if not, I'll let him kind of go through it, but
Yeah.
the motion to approve is to approve these two items.
To approve the text amendment with the additional included in the text amendment so that it applies to any future, applicant or owner of this property, that any site plan that's submitted pursuant to this amendment would be subject to further 830G review. And it also would be amended in accordance with staff comments.
Doesn't it go without saying that we would have further 8-32 review of any site plan to get as a
Well,
compliance review?
That makes it very clear.
The answer to that is, I don't know, but that was something that Commissioner Levy and I during public hearing wanted to make sure that was explicitly clear.
And the applicant has
So let's
agreed
go-
that that can be part of it.
Our staff has pointed out they can't do the project.
Well, hold on, now let's,
We'll get to that.
we'll get to that. But that's the motion, but move-ins, we'll go first, as we normally do. So Commissioner Levy and Commissioner Randolph, and then we'll go elsewhere. Anything further?
Yeah, I just,
Sorry, Commissioner Braun.
yeah, I mean, in my 7+ years, I think this is the first time we've had an application for a text amendment under 830G without a site plan, so it's rather novel. We know under 830G that normally you can submit just a site plan and you don't even need a text amendment. We know that from Beach Road. We also know that from the Berger decision in Town of Branford versus planning and zoning. So theoretically, a site plan could have been submitted without a text amendment. Also, 830G in general does not require a text amendment. But many developers want it so that they can get a zoning compliance letter in connection with financing. So any text amendment is subject to 830G. But normally, again, under the basic 830G, you wouldn't even need to submit this conceptual plan. It's only because section 8.3, I think it's G, provides that a town through regulation can require that a site plan submitted also include a conceptual plan, and Fairfield pursuant to 2.44, the Affordable Housing Statute, has adopted such a regulation. So this site plan has been submitted, or this conceptual plan has been submitted, but to say that it's the bare minimum is an understatement. And it doesn't address many of the concerns which would be fully hashed out in connection with a site plan application, which would include all of the details that are woefully lacking in this application. So that I think would all come within the context of any site plan that may be submitted. And equally at that point would be the issue of the environmental concerns, which are substantial. I don't think inland wetlands are subject to the same burden as we are with an 830G, so they're not coming back in front of us until they've gotten past that hurdle, which in and of itself might address many of the issues presented by this application. For instance, the lot coverage. Again, with a site plan, while you might be allowed up to 10,000 square feet, that would not be the case where there's environmentally sensitive areas and where the calculation of the square footage allowed is subject to exclusion of inland wetlands and areas that are protected. But I think that issue would appropriately be addressed down the road. I mean, in terms of the density here, I mean, it's less than the density on Black Rock Turnpike. In and of itself, I can't say that this density poses a threat to the public health and safety. When I see the building that's actually proposed, that may be a different standard. Equally, the environmental impact, I'm not able to say at this stage, and that would have to be reserved. So just so the record's very clear, all of these significant concerns that I have, I think would be addressed when and if a site plan is ever proposed. As to whether or not this requires a supermajority, well, that's something that'll have to be determined. We'll see depending on any vote on this issue. But again, I just want to make it very clear that while the text amendment in and of itself and the limited value of that conceptual site plan, I don't think that in itself would justify denying the text amendment applicable to this property as posing a threat to any substantial public interest. I totally reserve and expect to fully address at a later time. If I'm still on the board at that point, if the site plan comes before us as to the other concerns, which would all be addressed. And I think Commissioner Randolph would like to speak to some of the other things that might be expected at the time of the site plan, which are not appropriately part of the text amendment. Thank you.
Commissioner Randolph.
Thank you, Commissioner Levy. I'll be supporting the approval of this text amendment, but it doesn't mean we'll be supporting the approval of this project. There's still much that remains to be evaluated, as Director Harrigan detailed at length. There are many issues that are problematic with this. But we don't have enough information to determine whether there's substantial public interest in health and safety at risk, and that these interests outweigh the need for affordable housing, which is the criteria for us to accept or reject something. So I'm just, for the record, I'd like to get down what things need to be evaluated. And these really build upon what Director Harrigan was saying. There needs to be an evaluation of the wetlands and open space by a certified soil scientist to delineate all the inland wetlands and water courses in the subject property. This was cited as an issue. It's a very sensitive area, and a mitigation and planting plan will need to be prepared by professional wetland scientists if possible. And when I say if possible, that's if the project goes forward or there's a reasonable solution, not whether the scientists can prepare it. And there needs to be proper buffers identified to protect the wetland resources from stormwater. And all this needs to be in compliance with Connecticut state statutes. There needs to be a wildlife and deep review of the site. It's a sensitive area, and the applicant shall submit to the project for the project a Connecticut Deep Natural Diversity Database report and any mitigation measures. Floodplain protection. This is identified. This property is in the floodplain, and we need a Connecticut licensed professional engineer to prepare a grading and drainage plan for the entire development, and what's called a zero rise analysis, which was identified by Director Harrigan as being an issue, to assure that the finished floor elevations comply with FEMA and town floodplain design requirements. Wastewater. We need written approval from the Water Pollution Control Authority conforming adequate capacity. Right now, there's a proposal to extend this. No approval has been received for this. Water supply. There's general reliance upon a water supply being there, but there's nothing in writing, as well as other utilities. Traffic impact and sightline evaluation. We need a traffic impact analysis, TIS or TIA, prepared by a licensed engineer to address sight lines and according to professional standards. Emergency service access needs to be evaluated. Stormwater management system shall be designed in accordance with the stormwater quality management and applicable deep permit requirements. SHPO, which is historic preservation. There's a historic structure on the site. There was no information provided for that. So the applicant shall obtain written confirmation from the State Historic Preservation Office regarding the historic resources on the site. And any mitigation measures required by SHPO shall be incorporated into the site plan, as well as construction safeguards, bonding. And once we have that information, then we can make a determination on whether or not we can approve the site plan. But right now, we don't have any of that information, so the approval is to approve only the text amendment.
Thank you. Commissioner Braun.
I will be voting to deny this, both the zone change and the text amendment. I think what limited evidence there is indicates that it will cause harm, but it is almost impossible to determine, and that's a horrible flaw of 8-30G, that we have to evaluate a proposed text amendment to our own regulations when regulations are not even needed to be followed by an 8-30G applicant, and as well as a change to our zoning map based on a concept. We can't do it based on a concept plan. We don't have the data, and it's almost insulting that we have to do this level of review. And 8-30G, which flips the burden on us to prove there's evidence in the record that would show substantial harm. We should not be required to do this, and I think what little evidence is in the record shows that there will be harm. It shows that there are unidentified wetlands on the site. This is close to the headwaters of Quicker Brook, which is a tributary to Mill River, which flows 8 miles south of Easton into Southport Harbor. We have to protect our river and our wetlands. There was no information provided about wetlands or watercourses. We have concern from our Director of Conservation that this will impair the wetlands and the watercourses on it and off the site. The FEMA issue is significant, that they are not providing adequate, they have to fill to create the right elevation, and then they don't have adequate flood provision. Also, they didn't even go to WPCA. Basically, it's an end run against 8-30G for the site plan. Why wasn't a site plan provided? I don't know. But this is an end run. They could have provided a site plan. They could have done the detail required, but for whatever reason, they didn't. They're asking us to approve a regulation and a zone change for a future application to be filed after our moratorium. So this came in obviously before the moratorium was granted on 8-30G on April 1st, and it's an end run. So I do not believe we should have something that, first of all, isn't even needed, but secondly, what little evidence we do have shows that it will cause harm. It's almost impossible to come up with detailed figures because there's not enough information provided. I don't think you should be able to get around 8-30G by giving us lack of information and asking us to approve a zone change and a text amendment to our regulations that A, aren't needed, and B, do not have the information to support them. And what little information we have shows it should not be approved. So the experts supplied information about harm to the historic nature of the Merritt Parkway. We have harm to the wetlands that's been alluded to by our conservation director. We have an expert right in our staff for FEMA that says there's a problem there. Their own regulation they're proposing will not support the concept review that they've submitted. So their plan does not even qualify under their own regulations that they're proposing, which again are not needed. So I say based on what we have been provided, there's enough indication that there will be harm to the environment and historic aspects, and we don't have enough to even determine traffic. But I think there's enough in here to show that these regulations should not be approved because what little we have will cause harm to public health and safety. So I will not be supporting this.
Thank you. Let's see if anybody else wants to jump in. Commissioner Corsillo.
Thank you. And again, thank you, Ms. Harrigan. I agree. This is very extensive comments, so appreciate the thought that went into that. As Commissioner Levy said, this commission finds itself in uncharted territory with this application, which forces us to decide on zoning regulation amendments without and a zoning change under 830G without the benefit of a site plan. And while this commission certainly can consider zoning regulations absent the site plan, our discretion in this case is constrained because we're not permitted to deny an application simply because we don't have sufficient information. We can deny an application if the evidence in the record demonstrates a quantifiable probability of specific harm to public health and safety. And here we have a catch-22 because the applicant opted to submit an application without a site plan. And without a site plan, it is difficult for the commission or the public to produce evidence, frankly, one way or the other. And I'm disappointed that the applicant went this route for the reasons that my fellow commissioners have stated. I don't think the explanation given for this approach was credible, but it's the applicant's right. And so we're left to make a determination on the application we have before us. And having read and reread the general statutes on 830G and what is within our purview and our jurisdiction repeatedly to try to get clarity on this commission's obligations under the law, my interpretation is that the conceptual site plan, a final site plan not being needed leaves us to weigh in on the regulation amendments and the proposed amendment that's been offered by Commissioner Levy to proactively require the applicant to come back with a site plan that would be subject to a full 830G review, I believe, is essentially the reasonable accommodation we're required to find. Because in this case, that forces the applicant to address the many deficiencies that have been outlined by Ms. Harrigan and by the other commissioners who have spoken. So while I agree with the all of the concerns that have been raised, again, the applicant now must come back. I think it sounds like this is a requirement that will have to be considered for any similar applications that lack a final site plan moving forward. And that will be the time when we will have the information required, both for us to raise the questions that I think need to be asked and for the public to make its case, present any evidence that the project would cause a substantial threat to public health or safety in its mind. So based on what we have, I think I will be supporting the motion to approve with the conditions stated.
Thank you. Commissioner Harrison?
Yeah, I just have a question for clarity to Planning Director Harrigan. I just want to get some, I'm hearing from commissioners, and I say this in a respectful way, that I support it, but we will absolutely, have a more thorough, review of things when we get the full site plan. What that would, we would have to do that anyway, right? I mean, I'm not clear on, that's not, I guess, what am I missing here? Is that what you said in your statement?
Right. I do think that if you add that specifically within the, I mean, I
What
don't
would
know
happen if
quite-
it
I don't know
wasn't?
quite how to address this.
All right, try.
Go ahead, Chair.
My question,
Yeah.
maybe it was
Yeah,
just,
go ahead.
maybe it was just not well stated. I'm sure it wasn't. Any application would have to come before us, whether we state it or not, correct?
That's correct, but I think by asking for approval of this with a conceptual site plan, it narrows the review for the applicant a little bit more, I think, based on the regulations that they've proposed. But I think that's up to the commission to decide whether they can strengthen the regulation as proposed in order to make sure that you're getting what you want.
Concern that was expressed at the time was if you just have this regulation, assuming again, it's granted. It's under 830G, but you have a regulation and you make an application under that regulation without Commissioner Levy's explicit, this future application is under this standard. What is it actually under? Is it under what you would, like a regular regulation, a regular special permit? You know, is it just like that, or is it under the 830G standard? So that's what he's looking to do. And that's wants me to be explicit about that. Go ahead, Commissioner Levy.
Thank you.
Yeah, if I can address that further and
I know you want.
just as an aside, in terms of the timing of this application, this does not address whether or not when a site plan is submitted, whether that will be viewed as a de novo application, which submitted during the moratorium and is or is part and parcel of this existing. We're not addressing that. We'll deal with that down the road. But I'm thinking, and I'm literally thinking out loud, because the nature of my amendment was consistent with what the applicant had agreed to, because we were concerned about this later on being considered as just a special permit application under zoning regulation, which is why we have the proposed amendment. But as I'm listening to Commissioner Randolph's list of expectations, I'm thinking that we should also have a second amendment, which might be independently challenged if the petitioner so chooses, as a reasonable accommodation for this very sensitive site, that in connection with any site plan submitted under this zoning regulation, as part of the text amendment, it is understood that any site plan would include, and I'm just referencing the ones he stated, the wetlands and open space condition with a certified soil scientist addressing those concerns. The text amendment, this second amendment, would provide that the applicant would need to submit evidence, the floodplain protection, which Commissioner Randolph mentioned, the wastewater concerns would have to affirmatively be addressed in connection with that application. The traffic and impact and sight lines would have to be addressed, and the stormwater management. I think all of those could be made part of an additional amendment to the text amendment as to affirmative obligations of anybody submitting a site plan for this site under this amended regulation.
Great.
That would require a second approval.
You making that?
I'm requesting that be a second amendment
Okay.
in addition to the one already made.
And then there was also reference to historical, to SHPO, I think Commissioner Randolph
That
said.
might be, in my mind, that might be over as well.
Okay. I don't have a printout. Okay. I'll look at your printout. Thank you.
Yeah, that one I felt might be.
All right, well, let me,
Are we addressing the protest petition now also, or is that separate?
That's legal.
that's something we can discuss in a second. Let me clear this up. Commissioner Levy, the move into suggesting a second amendment to his own motion, essentially he listed as what,
The wetlands and open space criteria, the wildlife deep review, the floodplain protection, the wastewater protection, the traffic impact sightlines and stormwater. That any application would have to affirmatively address those issues as more fully set out by Commissioner Randolph.
Commissioner Randolph, are you okay with that
Yes.
amendment? Is there any objection to that?
I have a comment, but maybe not an objection.
Okay, so
I
let's.
would, I
hold
mean.
on, hold on.
Okay.
Oh, I'm sorry, you have something else to
No, I
add?
just want to,
I just want to get
we
the
may have
amendment.
different opinions of what is above and beyond, but I would like to, in the second amendment, I would like to see all of these, reviews in there. Going down to the historical preservation, because this is a historical home. So I think having some documentation on that would be important for me anyway.
My only concern is that might be far more than we require in any
SHPO's required.
But the Merritt Parkway is the largest historic asset in our town, as it is in every town it goes through.
Hold on, because I need to get the record kind of clear where we are.
I could.
Hold on. Commissioner Levy's made the friendly amendment to his own. It's been okay with Commissioner Randolph. At this point, is there any objection, or can we just have that for now and move forward? Not hearing an objection, so it's so amended in that way, and we'll address it later. Okay. What's the point of order?
Question. So, Commissioner Levy referred to my elaboration. How do we formally incorporate that into the amendment?
Well,
Speak up a little. I can't hear you.
he's asking how we how do we formally put what Commissioner Randolph had written down into the amendment? I would give that to staff.
Okay.
I think this young, Director, Ms. Harrigan, you understand where we're going with this?
Yes.
Okay, so-
I just would like to see them, I think, explicitly read as an amendment, just so it's in the record.
Okay, well,
If
he
you
did
don't
read,
mind.
well, let's get to that later, because he did read it. I think we're all kind of on board, but we can do that at the end, or towards the end. All right. Anything? Yeah, let's see if Commissioner Ford has anything, and I may jump in quickly.
No, I'm just listening.
Fair enough. Let me throw my 2 cents in this, because this is for such a fairly small site, this has been a complex application for all the reasons that have been stated. I think the statute allows for what they've done. I don't like it. We see problems like we saw this in Westport where there was a site plan only, conceptual plan with regulation amendments only, and then they came back, and it was completely different than what they were expecting. So that is an absolute threat or concern that we have here. But it seems like the statute and the related regulation allows for them to do this. Not to say that it's the right way of doing it, it just seems like that's the way they're allowed to do it, and it is what it is. We also have the unusual circumstance where the applicant, except for the regulation amendments, the proposed regulation, the conceptual plan, and a traffic report, has literally provided us no other information. Which is not usual, because when you get a site plan, you normally get some kind of presentation from experts from the applicant's end to say that what they want to build can be built, without drastic harm, any harm to public health, safety, we're used to. Fire, traffic, drainage, and environmental. We don't have that here, which is somewhat unusual in its own right. But we do have the only evidence that I can see as to impacts of this site, again, exempting traffic, because they gave a traffic report of sorts, but it was something. Is from the opposition saying how this is going to impair health, welfare, safety, and the historical asset of the Merritt Parkway. So when you look at the record, the only real, again, exempt traffic for now, because again, they provided some evidence with respect to that. The only other evidence for everything else that's been discussed, fire, less to the extent of fire, but more environmental and drainage and the historical preservation of the Merritt Parkway, is in the negative. So record reflects more than anything else that this potential project and the opposition this potential project will impair the health, wealth, and safety. The additional problem with this is with the opposition's experts not given information, do what would be an expected full analysis, because you get everything that goes with it, all what we're used to with drainage issues, with the design and all the calculations that go with it, or the impact of the environment. They can actually do a full review themselves. And here, the best they can do is assume max build out, which is fair, because that's what I would expect, and do the calculations in their analysis as best they can. So it's limited to some extent. Their analysis is limited, but inherently so, because that's what they were given. So, I think that the motion, in its attempt to kick the can down the road, is the wrong way. It's to preserve our rights to actually look at this later, is fair. And I think the only alternative that we can have, to that, the alternative, if we were going to grant it, I may have some suggestions if we go down that route, but at the same time, I do feel that we have some basis to deny this, because There's another one we've seen, and we don't need to conflate two, but the one on Black Rock that we're seeing actually has some applicants providing some information about what they can do. And they're giving us some information that, yes, this can be done, yes, this can be done. We don't have that here. And if we're bound by the record, in this case, we have to look and see, we have the burden of seeing what in the record supports a denial. The only evidence, again, exempting traffic, but towards Bear Parkway preservation, environment, and drainage is in the negative. And as best in the negative as it can be, considering the limited stuff we have. So, you know, I'd like to almost somewhat set a precedent that if you're gonna come to us with a conceptual plan, so be it, but you gotta give us something to work with. And it could just simply be that this site is just so unusual with environmental. You know, this site, if this application was somewhere a little more, you know, Black Rock or somewhere like that, where you actually, you know, maybe this wouldn't be much of a concern because there's less of environmental. But, you know, in this kind of area with the environmental considerations, the Mare Parkland Conservancy, preservation, excuse me, and drainage that really will affect the other areas, you know, I think we have a basis to deny it, and I'm leaning that way because I think that's, you know, a fair way to go and let them test it in court for that simple reason, because if there is an appeal of it. My only thought is if we are going to do an approval of the regulations, one thing I would suggest is a sunset provision that this would only be good for 1 or 2 years. But we can discuss that later. And finally, and I'll let somebody else talk, is if we go down a denial route, if we get the sense that that's where we're going with this, I would suggest that the way to handle this might be, even if we have a vote on this current motion or it's withdrawn, that we have a motion for deny to kind of outline what the issues are. But then to safeguard ourselves, I think that we should have something in the alternative that should the courts overrule us, then we switch over. The alternative decision is that these reasonable accommodations are essentially what you said, Commissioner Levy, combination of the amendments that you have plus the staff ones as well. What I would hate to see is if we end up denying this, going to court, potentially getting overturned, because that is a possibility, but none of the amendments that you're suggesting, Commissioner Levy, get included into the potential regulations that the court affirms. So that's the quandary I think we're in. Is I think most people understand, everybody I think that's in support of this understands, again, you're safeguarding and preserving your ability to look at this as we normally would later when we actually have the information. And I wonder now, you know, we can certainly do that. I think that's fair. But I think if the applicant is literally going to give us nothing, why not take that somewhat and, you know, they have to live with it, so to speak. I do think they somewhat have the burden initially to prove to us that what they can build is not going to substantially harm the area. I think that's pretty basic American jurisprudence, that when you're coming forth, you should have a basic, you know, it's not completely on us right off the bat, that they have to do something at least. And if they didn't do that, then they should live with it. But my other suggestion would be, if we did end up denying it, that we should do something in the alternative to at least put forth, Commissioner Levy, what you suggested in your motion. Yeah, so I'll let Commissioner Levy go, because I
fully appreciate your position, and I had considered that. But my concern is, spending 47 years in courts, that if we deny it, with or without conditions, but simply deny it, if it gets appealed and we're overturned, then the regulation amendment would be approved. And the issue as to what further review or what standard would apply would not be before the court at that time. We would then simply have by default, a new text amendment applicable to this site. And then should we be presented with a simple special permit request, as happened in Westport, there would be no condition, as I've suggested, in connection with that review. And then the only issue that be appealed would be what was the standard. Whereas this way, we are basically passing it with a reasonable accommodation, which is we're addressing the text amendment, which in and of itself, without a site plan, doesn't necessarily pose a threat to health and safety, or a substantial concern for that. The site plan doesn't, but with these, as it applies to this particular parcel and what's going to be expected of the site plan, we're making it very clear that this is environmentally sensitive, and anyone pursuing a site plan under this, text amendment will have to comply with this. And that way the court will address it as to whether or not our reasonable accommodation, being my two separate amendments, the court would address those separately. And then we will know going down the road what the standard is on the review. So.
And that's my concern as well, that's why I think we wanted, both of us had said we wanted that standard explicitly put out there, because we grant it without it, and then they get a new attorney to come in and they just assume that that standard doesn't apply.
Right.
Yeah, so I mean, my thought of then, if you don't mind me talking, Commissioner Levy, my thought then, in your mind, may be a little too aggressive and untested, because I don't think I've ever heard of a commission having a denial and then do something in the alternative.
Right.
Courts do, obviously. Yours may be a little more of a safeguard than.
No special conditions for it not, that I'm aware of.
No, I know, but it's more of the alternative to put out to the court. Again, it's just, what's irking me is that they literally provided us nothing. Harrison, and
Yours is riskier, I think.
Harrison, and then Randolph.
No, I appreciate the really good discussion tonight, and I think just thoroughness from our planning director and from my fellow commissioners. I'm gonna have to, I'm leaning towards a no right now. The words I heard tonight were lack of information. I think I heard insufficient information, few details. And I think a very basic part of a text amendment, I think we should be getting some kind of basic plan. I don't think when the legislator, brought forth 830G 30 years ago, they would intend for commissioners really like us to have basically nothing. I don't think that was the intent of 830G. I do, and I'm happy to take it to the court, quite frankly. I think the applicant did us a disservice by not providing us a lot of information. He had that option. He chose not to. That's on him, not us. At the end of the day, we're gonna have to live with our decision. And I think I'm gonna be a no right now.
Mr. Randolph?
I believe we all have a consensus on really the potential harm of this project, but we don't have any specific evidence of harm, and that's the legal standard. I looked at the issues from a design and constructability standpoint, and I put these together, making sure that we would retain the right to conduct these reviews rather than relying on the not always consistent judgments, verdict of a judge. Judges are not, many judges are not technical. By putting the second amendment in, the second set of conditions in, we retain these technical reviews, which I think we collectively share. And just to, recap on some of those, it's the wetlands, it's the flooding, it's the historic preservation. If we deny this, the future of this project is going to be determined by a judge who may or may not have a technical eye on this. And so that's why I went through and put together these technical matters that would retain our ability to review it systematically.
Commissioner Carcillo, then Braun.
Yeah, I mean, I understand both perspectives, the reasons for supporting approval and for supporting denial on this. I think this is the decision that I've had the most difficulty with of any that since I've been on the commission, with weighing this as recently as today. I think ultimately, my support for the current motion is largely because I think we have the greatest control over our ability to protect the town from potential impacts over whatever the eventual development is by going this route. Where we still have an opportunity to not only review, but with the review comes our ability to require reasonable accommodations, AKA changes to the project to address any harms or other negative impacts that we see once we have the additional information. And I worry that a denial leaves it in the hands of a judge. And as has been stated, we can't deny with conditions. And so we don't know what the judge would do. Should we lose the appeal? That may be it for us as far as our ability, not it for us, but we may have substantially less ability to impose any additional conditions on the project to protect impacts that the project may have.
Commissioner Braun?
Yeah. I think we do have evidence of harm. We have our staff, who has said that there is inadequate emergency access or delivery access. That's harm. We have the lack of floodplain offset. We have harm to the wetlands and watercourses, and we have harm to the historic nature of the Merritt Parkway. And that's adequate. That's just as important as anything else. That is one of the things we may consider. Historic assets and natural resources. It's not specifically spelled out in 8-30G, but those are things that we may consider because they're within our jurisdictional authority. So there is harm that has been presented to us, and that is an adequate basis for us to deny, especially here where we got almost no information on which to put any metrics together. So we do have enough to offset what little we got. And then as far as the protest petition, I disagree with Judge Berger's decision. The protest petition is a separate statute. It's not a regulation. We can follow another portion of our zoning law, which says that if enough people think it will harm them because they're in close proximity to this development, and if they sign a protest petition, then it requires a supermajority of this commission to approve a change of zone, a change of our zoning map. That would require, instead of a 4-3 majority, a 5-2 majority. Which means if 3 people vote no, this zone change will not go through and this project will not be built. And that is what the purpose of the protest petition is. It's been around since the beginning of the zoning law. I studied this for one of the bad zoning bills they wanted to pass. I studied the history of it since I think 1959. The Supreme Court of our state has concluded that people in close proximity to development are more impacted than other people. And that's why they get special consideration to file a petition to require a supermajority if we're going to approve a development that could harm those in close proximity. So we have a protest petition. And I think we have to avail ourselves of the law that has been held by our Supreme Court since, I think, 1959. So I don't agree with that decision that says 8-30G eliminates the public policy of our state. It says people nearby require extra protection. So I think we should also vote no on the zone change as well as the zoning regulation.
Let's discuss that quickly. It's pretty clear to me that Judge Berger's decision is on point with the 830G statute. The supermajority does not apply in an 830G application. I think that's pretty clear. Would you agree with that,
I mean,
Commissioner Braun?
I don't agree with what his conclusion is,
That's fine, but you would agree that
and that's a Superior Court decision.
it's compelling law to us, right?
Maybe you do, not to me.
I would like to see that tested in the court system up to the Supreme
Well,
Court.
I mean, listen, we sit on us like regular court, we're a quasi judicial board. And we sit on the low end as the finder of fact. And when we appeal, we go up to the Superior Court and then it goes appellate and supreme. Sits above us. It is compelling law. I mean, just by, and I mean that more in a technical legal jargon of it's from a court of a higher authority than us. And I think that's just factual. So, you know, it may not be tested in the appellate or the Supreme Court, not like it, but much like a superior court, who's in a regular lawsuit, it's a trier of a fact, and the appellate court above it, you may not agree with the appellate court, and the Supreme Court may not have ruled on it, but it's compelled by the appellate court, so we have a similar compulsion, I believe.
I don't think we're bound by it.
Well, again, that's fine, but I mean, I don't know anything I said that was inactual and factually inaccurate or legally inaccurate, so. You know, that it is what it is. So, I mean, I think we have no choice but to follow the Berger conclusion that a 4-3 vote would be enough, and I mean, should that go that way, that's, I mean, as chair, what I'll pronounce, because that's what it is, what it is. All right. Commissioner Levy.
Final thoughts. I appreciate your concerns, but I think those are concerns that are not presented by the text amendment, but by what ultimately is submitted to be built on this property, which is why I've included those amendments to address it at the appropriate time. But I think at this point, the mere language of the text amendment does not present any evidence, or there any evidence that the language of the text amendment in and of itself poses a substantial threat of harm to the public. So on that basis, I think, we should approve it. I'd also point out, I mean, the concerns about the lack of information are real. But, what's the court going to do with that outside of Fairfield, where we've passed a specific regulation which requires, in connection with a text amendment under 830G, that we require a conceptual plan. But for the fact that our town has passed that regulation, a conceptual plan would not be submitted at all. I'm not sure about Bridgeport or Milford, but unless they've passed a regulation, the text amendment need not contain a 830, I think it's 833G or something, provides. It's only if we request it that we get it. Other towns, it could be a straight text amendment. So, in the lack of information as to the text amendment, I don't know that would fly, that reserve it till the time of the site plan with those conditions. As to the, super majority, I think, the section 8-3 was passed probably about 80 years ago, 830G more recently. At the time, what wasn't around previously at the time of the supermajority provision was the state's adoption of a specific concern for having affordable housing. And it raised a standard by which the commission, can approve or not approve an 830G. And that's a very high standard. In other words, it's very much the state position that affordable housing is a primary concern. And if affordable housing could be blocked in any neighborhood by a partition of 20%, then there wouldn't be affordable housing anywhere in this state where people organize. So I think, I don't think, I agree with Judge Berger, and I think as a Superior Court judge, it's not appellate law, but I think it's particularly in light of Judge Berger's, standing, deciding most of the 830G law up until this time, until recently, it carries a great deal of weight. And frankly, I find his analysis in Housing Authority of Town of Brantford versus Planning and Zoning Commission of the town is compelling. So, and also that depends on the vote here as to whether it's even applicable. But in terms of, whether there's a harm, and so forth, I don't know that that's a concern with the mere language of the text amendment at this point.
I wouldn't mind offering a friendly amendment, though, that we include evidence with respect to maybe not the historical preservation of the house, but of the Merritt Parkway Conservancy.
That would be acceptable to me.
Yeah, because I think that is a concern. We've addressed it in the past. I think that needs to be addressed now, or at least preserved now as well, to be something to consider, because I think that goes in line with what you're talking about.
Exactly.
Commissioner Randolph, as a second, is that acceptable to you?
Yes, I currently say the applicant shall obtain written confirmation from the State Historical Preservation Office. I can add the Merritt Park Conservancy.
No, I don't want you to add, it's not to add their opinion. I can kind of guess what their opinion is. But it's just to have, following your logic of having topics be addressed by someone who's able to opine on them, having them address the Merritt Parkway, the preservation of the Merritt Parkway would be a topic to be addressed
By the applicant.
by the applicant, excuse me. Is that fair to you, Commissioner Randolph?
Yes, that's in line with my intent.
Is there any objection to that friendly amendment? Not hearing anything. And I'm sorry, ladies and gentlemen, I apologize for how long we're going, but this is difficult. The final one I would suggest is a sunset provision. And I don't know the time off the top of my head, but I wouldn't want this standing out there for too long, this district regulations. I remember Attorney Bellis maybe in a separate one, or this one saying that would be okay. Obviously dependent on the time. Any thoughts on that, or just leave it be? Years.
2 years, I think, in light of how long things taken forward would be too narrow. I mean, I think a fair one would be considering how many, it might be appealed once or twice. Make it 5 years.
5, I would just leave it be. I would say 2, and if they're gonna appeal it, this will be part of the appeal and it'll be addressed by the court, I guess.
Building permit is good for what, 12 years? 15?
It's above.
May I make a suggestion?
Yes, Ms. Harrigan.
Do you want to have it sunset at the end of the first 4-year moratorium? Because then they could submit an application in court for the next 3.5 years. Then they can submit another application after that time.
It's kind of a small issue. What do you think? 4 year,
I could go with 4 years or.
that's fine with me. Commissioner Randolph,
2 years is consistent with other sunsetting provisions, just for the point of information.
all right, I'll leave it back to you.
I'd be more comfortable with the 4. I think that's more reasonable, knowing how long stuff takes in court.
Commissioner Randolph?
I was just providing information.
No, it's fine. Are you okay with that?
I would prefer 2, but I'll agree to 4 for the reasons provided.
Any objection to that potential friendly amendment? Or Harrison?
Yeah, I would like to have a 2-year.
So if there's an objection to it, then we have to make a vote on the actual amendment itself. So, I mean, if your thought is in the denial, but your objection stands. I don't feel the need to call a motion on the amendment, then we can just.
It seems kind of substantive that I think it should get a vote, but. that's me.
Then make a motion, I guess, because we were trying to put it in as an amendment.
It's not my motion, so I'm not.
Yeah, I know, okay, I get it. Okay. Anything final?
Well, I can't think of one situation where you could actually review a regulation and determine that the regulation itself causes harm. Unless it's associated with the project, then you could look at the details of the project and see the harm. We don't even have a detailed project here. So how can you ever review a regulation and say that it causes harm, especially when the regulation isn't even needed? It makes no sense to me. And to me, it's just an end run against the fact that they didn't get their application in before the moratorium was issued. It's a whole loophole in the 8-32 law. And I think we should challenge it.
Well, I mean, listen, you just kind of said it yourself. You said it's a loophole, and the reason it's a loophole is because I think in statute, You can, if it says that municipalities can pass a regulation to require conceptual plans to have certain things, then the statute's saying you can move forward with regulations with a conceptual plan, or at least have a conceptual plan that only hits those certain items, which it looks like they did. So I mean, and the regulation, I think, is even clearer on that point. So, I mean, anybody can, as somebody said earlier, anybody can come to do a regular amendment, regulation amendment to us without any site plan. That's common.
Mr. Chair, you have Commissioner.
Oh,
Ford.
Commissioner Ford.
Yeah, I'm not supporting the application. I think they're asking us to speculate, on multiple fronts. That makes me very nervous. As the lawyers on this commission know, courts aren't supposed to speculate. We're supposed to, make decisions based on facts. And I don't think we have enough to make a decision here. I won't be supporting it for that reason. I mean, mainly because I'm not comfortable speculating on all of these issues, especially the environment, and especially the safety issues. Thanks.
Thank you. All right. Sorry, that's all. Does everybody know what the motion currently is as it stands?
Sunset in or out?
Nothing in right now.
It's not in, so just, there's no sunset.
No sunset. Motion is to approve with the condition, well, amendments or conditions that first staff, Ms. Harrigan had outlined that any site plan in compliance with these regulations and map would have to meet the 830G standards, significant harm to health, welfare and safety. And that the applicant in pursuing the application needs to come forward with, and I'll let Commissioner Randolph outline them, at least identify them, come forward with specific information with experts if needed about the following topics. Commissioner Randolph,
I'll just read
Just
the topic
identify-
headers.
that's all I have.
Yes. So number one is wetlands and open space review. Number two is wildlife deep review. Number three is floodplain protection. And I'll give you these in writing.
Yes,
Number four is wastewater review. Five is water supply. Six is other utilities. Seven is traffic impact sightlines. Number eight is emergency and service access. Number nine is stormwater management. Number 10 is historic preservation. Number 11 is Merritt Parkway Conservancy review.
well, the last two are the same. Is that true?
No, because SHPO is a state review regarding the house.
Yeah, but I don't think
Yeah, that was-
Commissioner Levy did not include that in his amendment.
Yeah, I also didn't include water supply, utilities, or emergency, because those are the standard.
Standard, okay. I'm okay with eliminating.
Well,
but
it's out, so I mean, just.
Yep.
Okay,
SHPO, I would, that's a state regulation.
we just went through this
Okay,
with the amendment and that was what the amendment was that didn't have SHPO.
but Merritt Parkway Conservancy is?
Yes.
Okay. So I withdraw SHPO reluctantly. And utilities.
Question about parking.
Oh, okay, what's your
Why are
question?
we saying shall not exceed 49 spaces? That means they can't allow more parking if they want more parking?
Because the current regulation said that they would have exactly the number prescribed.
Anything there. They should have more parking if possible. I mean, they might
If
need
the-
more parking.
If the project gets smaller, for example, they have to provide exactly that number. And
Right.
for whatever reason, we wanted them to have less impervious surface to protect the wetlands. They would still have to provide that number of parking spaces regardless of the environmental considerations. So that's why the text amendment proposed a not to exceed threshold. So there was a maximum, but it could be smaller than that.
I'm against maximum parking requirements that aren't needed, but
All right, so that's the motion that's on the table. We ready to vote?
we're just voting on the motion, not on the whole.
Roll call.
We're voting on the whole.
Motion with the
We're
staff
voting on
comments
the
and the two
regulation
amendments.
text amendment? So we're voting on the motion to change the text amendment.
The motion to approve with all the edits and amendments that I went through. Sorry. Okay, good. All those in favor, please say aye or raise your hand. All opposed? Okay. So it passes 4-3. Thank you for the good discussion, and ladies and gentlemen, I do apologize, but that was,
On the, doing that, that was the zone change also?
yes. All right. Next item, next three items I'm recused of,
What
so.
about the zone change?
We just vote for the whole thing?
Oh, I didn't know we voted on that too. Okay. That means the zone change didn't go through because of the supermajority required.
No, as I said, in light of the compelling authority from Judge Berger, it passes.
We had 3 votes against the zone change, right?
Okay. All right, I'm recused from the next three items.
Okay, I'll call the next three items together. Zoning regulation amendment, application of 105 Byro Street LLC for revision to the zoning regulations to add section 5.5 Byro Residential District to allow the construction of affordable multifamily housing pursuant to section 830G of the Connecticut General Statutes. 105 Byro Street, 300 Castle Avenue, application of 105 Byro Street LLC to establish a new Byro Residential District on land presently zoned Residence C, and 105 Byro Street, 300 Castle Avenue, zoning compliance application of 105 Byro Street LLC for compliance with the standards of the Byro Residential District to establish a 48-unit residential development pursuant to section 830G Connecticut General Statutes as shown on plans entitled The Gallery at Byro, a De Laurentiis development dated May 1st. Ms. Hargan, I will correct my oversight from last week and ask you to provide your.
I'll be brief on this one. Thank you. Emmeline Harrigan, Planning Director for the record. I'm going to summarize some of the comments that I have on this because they're similar. They're similar to some of the changes that were requested in the last application, so I'm going to read those in so that you have them. But it's because of similar reasons that I'm proposing those changes. For the purposes of review, the sections discussed are submitted by the applicant, but please note, should these regulations be adopted by the commission or by other means, that these will be section 3.9 of the reorganized zoning regulations in effect as of September 6, 2025, with all sections reordered accordingly. Similar to the prior application, the first section establishes the purpose and intent for the Byro Residential District Zone and provides definitions consistent with Connecticut General Statute 8-30G. However, in section 5.5.2, requirements as to planned affordable housing units, I also recommend striking the section that speaks to subletting a unit, as that is not permitted by the affordable housing plan nor by 830G. So requesting that be stricken out. Again, within subsection C, requesting that as a section be added that requires the equal distribution of units by location and size as referenced in the affordability plan recorded on the land record should the designation of the units need to change within the development. And then section 5.5.5 for the structure standards for the affordable housing development, a building not to exceed a total of 48 residential units. As shown on the gallery at Byro. Section sub C, parking spaces not to exceed 67 motor vehicles in the garage. And again, these are specifically should, through the building code process, the building permit review process, they need to modify the plans that we're not stuck having to come back to the commission should there be a slight revision to the project. Under section 5.5.7 for the zoning table of bulk requirements, again, striking out the minimum floor area requirement. This is not something that is permitted within zoning regulations per 8-2 of the Connecticut General Statutes. So just asking those to be stricken. A few modifications: maximum height of building not to exceed 60 feet, maximum bulkhead height not to exceed 106 feet for any projections above the primary roof from all grade points, including elevator shafts and stairwells. Section 5.5.9 parking, there shall be, and we're adding not to exceed 67 parking spaces in a garage that is part of the building. I will just reiterate again that per the Beach Road decision, the standard decision considerations for denial of a regulation amendment for an affordable project per the 830G statutes are that the burden shall be on the commission to prove that the decision is based on sufficient evidence in the record. The decision is necessary to protect a public interest in health, safety, or other matters within the commission's jurisdiction. Such interests clearly outweigh the need for affordable housing, and such public interests cannot be protected by reasonable changes to the proposed development. For the 830G site plan considerations, the subject site is approximately 18,700 square feet in size, located in the Residence C zone, which otherwise permits 1 to 4 family structures for lots ranging in size from 5,000 to 9,000 square feet in size. The site is presently developed with a former rectory building associated with St. Emery's Church at 105 Byro Street and a single-family residence at 300 Castle Avenue. The site has significant changes in grade from elevation 28 at its southernmost boundary at Castle Avenue to elevation 40 at the northern property boundary. The proposed 48-unit multifamily development per the 830G statute is comprised of 4 residential stories over 2 levels of garage parking with a rooftop common deck area. There are 21 one-bedroom units and 29 two-bedroom units proposed, each with its own office area that does not contain a closet and a balcony off the shared living space. Each garage level is accessed separately due to the grade changes. One entry is located off Byro Street for the upper level at elevation 38 with 35 parking spaces, and the lower level is located at elevation 29 off Castle Avenue with 33 parking spaces. The Castle Avenue elevation lower level is the highest height parking level with 13 feet clear, and it provides the lobby entry into the building, mailroom, stairway, and elevator access for pedestrians, and the loading area for deliveries, moving vans, and trash pickup. The building elevations are highest at the southern part of the site where both parking levels are exposed on Castle Avenue, resulting in 6 full stories with an elevator shaft stairwell projecting above the primary roof at these portions of the site. It should be noted that the exterior treatment for the garage level mirrors that of the residential floors, appearing more like a residential floor on Castle Avenue. The lower level garage is not visible at the rear of the site on Byro Street. As an 830G project, 30% of the proposed 48 units or 15 units will be deed restricted affordable for a period of 40 years. 7 units at 80% AMI and 8 units at 60% AMI, and distributed as follows. And I won't read the table, but it is included in the staff comments that I provided to you. The applicant's experts having indicated that the WPCA approval has been granted for this project to connect into the town sewer system, and public water supply is available at the site. The stormwater system has been designed to accommodate the 1-year storm event and is located below the lower level garage area. The applicant's traffic consultant's report indicates that trip generation for the proposed 48-unit building can be accommodated as the morning 18 trips and afternoon peak 19 trips to and from the building, as they are also divided between the garage access points on Byro Street and Castle Avenue. The project provides sidewalks along its street frontage along Byro Street and Castle Avenue. Driveway sightlines are adequately provided for each driveway exit. However, no parking areas are requested along both Castle Avenue and Byro Street at the building frontages to provide maximum visibility as well as adequate fire department access. The applicant has provided a turnaround area behind the building on Byro Street for fire truck access. No parking zone striping requires a condition approval for review before the local traffic authority. The town zoning regulations require 2-way drive aisles at a width of 24 feet. The civil engineering plans show the Byro Street entrance is adequately sized, but the Castle Avenue entrance is presently only shown as 18 feet wide and needs to be expanded to meet the safety requirement. It should be noted that the architectural plan showed 24 feet wide for both entries. TPZ staff recommends a condition of approval to ensure consistency and that this safety requirement is met. The proposed building provides a full interior sprinkler system, and the fire marshal's office department has indicated that access meets current fire code requirements. As requested by the fire department, all EV chargers are located on the lower level portion of the garage at the outside wall facing Castle Avenue. There are no inland wetland or upland review areas on the property, therefore no inland wetlands agency review is required. The Economic Development Director has recommended some changes to the final affordable housing plan, which can be completed prior to recording the required deed restriction on the property and prior to the issuance of the building permit. The landscape plan is shown on the applicant's sheet 5.0, prepared by J. Edwards and Associates, dated May 1st, 2025, provides 4 street trees along the Biro Street frontage. Neighbor testimony expressed concerns about safety issues due to increased cut-through traffic on Castle Avenue caused by increased trips generated by the development, impacts to schools and infrastructure, and increased hazards to pedestrians, including students and children, due to lack of sidewalks in the neighborhood. Many residents also question whether adequate fire department access was available due to the narrowness of adjacent roadways, significant on-street parking that additionally reduces road width capacity, and added impact of the dead-end configuration of Biro Street. Neighbors also expressed concerns about the significant scale of the building and loss of sun, particularly neighbors with installed solar roof systems who would experience diminished effectiveness of those systems. The commission is familiar with the standards for review of denial of an affordable housing application, and those standards were discussed during the hearing. The burden shall be on the commission to prove that the decision is based on sufficient evidence in the record. The decision is necessary to protect a public interest in health, safety, or other matters within the commission's jurisdiction. Such interests clearly outweigh the need for affordable housing, and such public interests cannot be protected by reasonable changes to the proposed development. Court cases have indicated that the record must establish more than a mere possibility of harm to a substantial public interest. The record must contain evidence as to a quantifiable probability that a specific harm will result if the application is granted. Mere concerns alone do not amount to sufficient evidence to support the denial of an affordable housing application. Should the commission determine that approval of the project is warranted, TBZ staff recommends the following conditions. 1, changes to the proposed zoning regulations for the Biro Development District, as indicated in the staff comments. Parking spaces within the garage be specifically assigned by unit in order to provide clear direction to tenants as to which garage entrance and parking level they need to access, thereby reducing unnecessary added trip generation to the adjacent residential roads. All garage driveway entrances to be a minimum 24-foot wide. A deed restriction for the set-aside development must be recorded on the land records prior to the issuance of the building permit and is subject to final review by the Department of Economic and Community Development prior to filing. No parking zone striping as shown on the schematic site plan, sheet 2.2, dated May 1st, 2025, and revised July 15th, 2025, prepared by J. Edwards and Associates, to be requested for approval for review before the local traffic authority. All stormwater detention systems to be designed to the satisfaction of the town's engineering department prior to the issuance of the building permit. And that's what I have. Thanks.
Thank you, Ms. Harrigan. So we have Chair Noonan and Commissioner Ford both recused for this item. I know Commissioner Collins is also online, so we have 3 alternates. Who, do you know who is up for this?
I think I would go by who's available to vote based on attendance for this item. And I believe that both Commissioner Siebert and Delgado had attended both of those items.
Okay, thank you. And I have a on the item, please, on the 3 items. Commissioner Randolph.
I move to approve with the conditions suggested by staff.
Thank you. Do I have a second? Commissioner Siebert.
Yeah, I second based on these 6 conditions.
Thank you. Commissioner Randolph.
This again, these 830Gs are difficult. This project does not represent good planning The building's out of scale. It's far too large for the neighborhood. But it's filed under 830G, which is, everyone's heard many times tonight, requires approval unless the commission finds substantial public interest in health, safety, or implicated, or such interests clearly outweigh the need for affordable housing. And such interests cannot be protected through reasonable conditions. The presentation of this project was a full site plan and it was complete. It was reviewed, and the issues that perhaps would have provided reasons for rejection were wetlands, presence in the floodplain, traffic, emergency access, stormwater. And none of those topics rose to a concern that provided clear concerns for public health or safety. So I reluctantly am approving this project. It's not in scale with the neighborhood, but we're obligated to abide by the law.
Thank you, Commissioner Siebert.
I agree with Commissioner Randolph's comments. I'm reluctant as well, but I don't see a chance for us.
Thank you. Other comments from the commission? Commissioner Levy?
Yeah, I too share the concerns and reluctance of this overdevelopment of the site, but again, pursuant to 830G, I don't see that there's any evidence of a quantifiable probability of a specific harm that outweighs the need for affordable housing. I also just want to point out that, at least tonight we have 7 commissioners voting. The matter was tabled or withdrawn last week because we had a unique situation where we had 4 commissioners present and the potential for the site plan being approved and yet not having 4 votes, which if 8-3B is relevant, which again will depend on the Berger decision. But conceivably, we would have been in a situation where the site plan might be approved and the text amendment denied. With a full complement of 7, that is not an issue that we need to worry about. So I will be voting in favor. Again, I see it as overdevelopment, but I don't see any evidence which would support it.
Thank you. Anyone else?
I have some comments.
Commissioner Harrison, go ahead.
Yeah, and thank you, and appreciate that. We do have a full complement tonight. Again, as I stated last week, when we did start to have deliberations about this, I did say I would be voting to deny it. I will be doing that so tonight. For a few things, I think there is some evidence in the record that does declare very articulately how bad this could be for this area. We had the head of the fire union, Bill Tuttle, a very respected, longtime veteran firefighter, who said the Fairfield Fire Department did not meet the operational benchmark set by NFPA 1710, the national standard that defines minimum staffing levels and response times for career fire departments. This shortfall, he said, limits our ability to effectively respond to emergencies in modern higher density structures, which many are being proposed and approved. Every new structure adds to Fairfield's fire load and places additional demands on our already taxed emergency response system. We also received another letter from a gentleman who is a gentleman who grew up in the area. He lives in another town now. He is a licensed lead traffic engineer, and he articulated, I think, pretty well just about the failures of the traffic study. And just how this area just really isn't made to accommodate such massive developments like this. I think most of us have probably driven that area. These are very, very narrow roads. I can't even imagine with cars parked on the street what that would look like. And again, I'm disappointed that the applicant, they made the development larger on Castle Avenue instead of accommodating more parking, which I think was a disservice. So, those are the main reasons why I will be denying this. We always say we don't like these things. We don't like, outsized development in these tiny neighborhoods. Well, our commission can take a stand on this. We don't because we're always afraid of litigation. I get that. But I think we do have to take a stand that these neighborhoods are being thrown away in many ways with this law. So I'll be voting to deny it. Thank you.
Thank you. Mr. Delgado, thank you.
I mean, I have to concur with other commissioners in that share reluctance, but considering other projects that we've seen, I fear that we wouldn't have standing in court, so I would be voting for.
Thank you. I will also be supporting the motion. I think the evidence in the record does not demonstrate a quantifiable probability of specific harm. I think the most compelling, Commissioner Harrison referenced fire concerns, which I thought were the most compelling concerns, but the recent Superior Court decision against New Canaan's denial of an 830G application specifically addressed that very issue, which was cited in New Canaan's denial of an 830G application, which also talked about insufficient fire staffing, and the judge in that decision said that that was not grounds for denial. And so with that left, I don't think we're left with any evidence that would support a denial, so I'll be supporting the motion. Any final thoughts? Okay, let's put this to a vote. All those in favor of the motion to approve with the comments and recommendations outlined by staff, say aye or raise your hands.
I'm recused, right?
Recused or abstaining?
I'm abstaining.
Abstaining, okay. All those against? And one abstention, so the motion carries 5-1 with one abstention.
I'm gonna make a suggestion, considering the time and the people here. Is it worth either adjourning or tabling these next few items during the length we've gone so we can get to the public hearing? I'm tempted with commerce because I think it is on the quicker side, but I don't know that. And unless anybody thinks otherwise, you know.
I think it'll go pretty quickly.
Yeah.
All right, so let's just do Commerce Drive then. Do we want staff comments, or can we,
I'm happy to, we can,
not that it's not worth it, don't get me wrong, I've read them. I just,
Guys are good. It's up to
no,
you.
I just see the time, and I know people are getting anxious probably for the public hearing, and I'm mindful of that. Can we, I'll call the item, does anybody want to hear?
I'd like to hear the comments.
Okay. We'll do that. I'll call those next items for 7:30 Commerce Drive LLC, items F and G.
I'll be quick.
No, that's fine, thank you. I'm sorry, I was just trying to.
All right.
Oh,
it's fine, we're fine. Don't worry about it.
This will be the last one we go to public hearing. Ladies and gentlemen, I apologize, but we've been doing this for a whole year. So at the same time, while I apologize, I mean, we've been working hard this whole year. Plus, once a week for a year, which is not what we signed up for. Sure, Ms. Harrigan, excuse me.
Emmeline Harrigan, Planning Director for the record. 730 and 770 Commerce Drive. You have before you an application for a zoning regulation amendment and special permit. This mixed-use development proposal, also known as 750 Commerce Drive, includes two components that require their own deliberation and vote. However, both applications are intertwined and there will be some overlap in this discussion. For the proposed zoning regulation amendment, the proposed site is located in the Commerce Drive Development District, existing section 13, section 7. For the new regulations, they are requesting approval for a transit-oriented development park project, TODP. The proposed project meets the requirements of this section, but the applicant requests to modify the zoning regulation section that pertains to the allowable non-residential component area. This is existing section 13.14.4, section 7.6.4 for the new regulations. The existing regulation allows a public plaza non-residential credit for properties which are not on a priority retail edge as identified in the 2019 transit-oriented development plan. And the applicant adds an eligible area, corner properties located on Commerce Drive. Additionally, the applicant adds a double square footage credit with the provision of a permanent public art. With the provision of permanent public art in the plaza. Prior to their submittal, the applicant made a presentation to the Fairfield Arts Commission to review this concept and get feedback. The FAC provided a letter of recommendation in support of the proposed text amendment with the following conditions. One, that applicants consult with the FAC for selection of a qualified artist, final design of the public plaza, and art component, and two, file an agreement on the land records for permanent maintenance and upkeep. TBZ staff agrees that a public art plaza within this emerging TOD neighborhood is a non-residential component that adds a much-needed community gathering area whose benefit extends to the entire TOD's district and supports this request also. The standard considerations for a zoning regulation change are as follows. Is the proposal consistent with the plan of conservation and development? Does time, experience, and responsible planning for contemporary or future conditions reasonably indicate the need for the proposed zone change? Have circumstances in the neighborhood changed substantially to warrant the requested zone change? Has it been demonstrated that the proposal is warranted and would serve the general health, welfare, and safety of the town? Does the proposed zone change promote a level of development that would serve to protect property values in the neighborhood and enhance the community and accomplish a transition in character between areas of unlike character? Would the proposed zone change permit a level of development that would increase undue traffic congestion? For the transit-oriented development special permit, the TODP, the proposed development site currently contains a 4,000 square foot restaurant with associated parking at 730 Commerce Drive and an 11,000 square foot light industrial building with associated parking at 770 Commerce Drive. The applicant requests demolition of both buildings, consolidation of the lots into a singular 61,152 square foot parcel, and construction of a mixed-use building comprised of 90 residential units, common internal amenity space and common entry areas, and 4,300 square feet of ground floor retail in the proposed 5-story building. The site also provides a combined 118 parking spaces in the basement below the building and on the surface parking lot behind the building, and a public art plaza oriented towards the corner of Kings Highway and Commerce Drive. The residential apartments include 4 studios, 58 one-bedrooms, 13 one-bedrooms plus loft, and 15 two-bedroom apartments, and 15 two-bedroom apartment units. 12% or 11 units are required to be deed restricted and affordable to households that do not exceed 80% of the area median income. At TPZ and engineering staff's suggestion, the project also includes a revision to the public right-of-way on Kings Highway East to provide 6 off-street parking spaces, which has been favorably reviewed by the Bike Ped Committee and approved with a posted 2-hour time limit by the local traffic authority. The project meets the criteria for a transit-oriented development park project, provided the zoning regulation request is granted for the additional square footage for public art in a public plaza. The applicant's experts have indicated that the proposed building architecture in the proposed public art plaza is intended to provide pedestrian amenities with the entries and planting beds with wide sidewalks located on Commerce Drive and the on-street parking and wide sidewalks on Kings Highway East that feed into the Arts Plaza that opens to the corner. Street trees are proposed along both street frontages as well as shade trees in the parking lot, in addition to landscaping at the north boundary. The traffic consultant indicated that the mixed-use project provides sufficient on-site parking for the uses proposed based on ITE analysis as well as analysis of the developer's other completed projects located on Commerce Drive. Additional public parking is available with the new 6 on-street parking spaces and at the Alto project across the street. The project site driveways are designed to be at the farthest points away from the signalized intersection. At the corner, bike parking facilities will be provided adjacent to the public plaza and internal to the project for residents. The proposed stormwater system meets town requirements for detention and water quality. Neighbors spoke from the Stone Ridge condominium that's project, but expressed general concern about the commercial use be one that is compatible with adjacent neighbors. Attorney Ambrose represented the property owner of the adjacent commercial property that contains the Bright Horizons daycare use. They expressed the following concerns: location of the play area, in close proximity to the construction site, and the need to provide additional mitigation for potential dust, noise, and debris with property line screening and stockpile protection. concern about the adjacency of the parking spaces to a walkway, play area, location of the proposed generator, and close proximity to the play area. Upon direction from the chair, Attorney Fitzpatrick consulted with Attorney Ambrose and agreed to erect construction screening at the property line adjacent to the daycare center, relocate the stockpile further from the daycare area, install a permanent vehicle safety barrier such as a timber guardrail along the parking area adjacent to the daycare, keep the generator in the current location, but install a sound enclosure with weekly testing completed at an hour that does not conflict with the daycare. Attorney Ambrose and his client would still like the generator relocated, but the only alternative location is closer to the street frontage and sidewalk on Commerce Drive, which is not desirable to the applicant. Attorney Ambrose also requested additional screening along the property line, but space to add this feature is limited with the installation of the guardrail on the applicant's property. At minimum, the commission may wish to include those applicant agreement items as conditions of approval in addition to those items suggested by the Fairfield Arts Commission. The considerations for the special permit are found in section 25.7.7. Is the development shown on the site and architectural plans of such character as to harmonize with the neighborhood, to accomplish a transition in character between areas of unlike character, to protect property values in the neighborhood, to preserve and enhance the appearance and beauty of the community, and to avoid undue traffic congestion.
Thank you, Ms. Harrigan. May I have a motion, please? Commissioner Harrison,
I'll make a motion to approve
with any conditions?
with the conditions stated.
So with the Arts Commission, certainly
Arts Commission,
screening,
relocate
relocate
the stockpile,
barrier,
install permanent vehicle safety barrier.
and a sound enclosure.
Yep, and keep the generator in the current location. I prefer to see it move, but it doesn't seem like it's possible.
So I just want to make sure. Okay. Commissioner Corsillo, do you second?
Yep.
Commissioner Harrison?
I think both the regulation and the site plan fit in well with and support the goals of the TOD plan and study that was done several years ago, as well as the current POCD. I don't believe it will harm property values in this highly developed commercial area. And because of the art space being added, it will enhance the area by allowing more green space and an attractive area for gathering and access for pedestrians and bike riders. The conditions of approval as stated will be part of this, which will allow for several safeguards. As I said, the only thing I would add is to move the generator further away from the daycare center, but that doesn't seem feasible. So I will leave that. With all these conditions of approval new and implemented, I think this will be an appropriate use of the site. So looking forward to supporting this.
All right, I forgot to ask, Commissioners Corsillo, Randolph, Levy, Ford, are you guys up to speed?
Yes. Yes.
Yes. Commissioner Ford, oh, he's recused because of Russo, yep, yes. So we need, who's still on this? Who's our alternate?
Siebert or Delgado?
Who's the first one up, I guess, among the two? All right, let me ask you this, you both are up to speed. Is there one that I just don't know who was like the
I
first one?
lost track, I
No,
apologize.
that's okay. You mind, Commissioner Delgado? Yeah, I know you are. All right, Commissioner Siebert then, just, is that okay, Commissioner Delgado? Thank you very much. Commissioner Corsillo.
I think this is a really beautifully designed building. I commend the applicant and Byfield for the design. I think in particular, the public art component is a really nice inclusion that I hope inspires other applicants to include public art, particularly in this area. I think it would really enhance that neighborhood. And I think this demonstrates a project can not only meet a need, but really enhance the quality of the surrounding neighborhood. So look forward to seeing this completed.
Commissioner Randolph.
I concur with the support for the project. It's refreshing to see a project that we are happy to approve. It's in the right location. It's the right scale. It's near other tall buildings. Tall buildings of a similar scale. We need housing desperately in this community. The quality of the design is at a high level. And the addition of art is an addition. I think it underscores the need for us to enact our transit-oriented development with more specific regulations that reflect this type of development. That's an example of the type of development and the location for development that best suits our town's future.
Thank you. Commissioner Braun.
I'm not going to be supporting this. I think it's too big, too much. It's displacing a small restaurant and a small business. And it does not accommodate the existing long-time daycare center next door. I think it's approaching the citification of our town. And even though it is in the TOD area, it could have been scaled back a little. And there's other places that generator could have been put other than right next to the daycare center. And they could have accomplished a little bit more screening. So I will not be supporting this.
Thank you. Yeah, I mean, to me, this was an easy project to approve. It fits our current TOD regulations, except for the public art space, and I would think that would be a pretty easy accommodation and desire. It meets everything else that we already have in place. And as stated by everybody else, high quality housing is a need. I disagree. I think they accommodated the neighboring daycare is best and as reasonably as I would have expected. So I don't know what else could be done about it. I think it's a great project. And as far as the criteria for the change in regulation, I mean, I think it fits all the criteria in the positive, especially when you're considering it only deals with the public art. And then it easily hits the special permit considerations in the positive as well. Can we put this to a vote? Anything else? All those in favor, please say aye or raise your hand. That's 6 opposed. Commissioner Braun passes 6-1. May I have for the next remaining items, H through M, motions to table, please?
Motion. Table, please.
Table, second, Commissioner Porcello.
I think it's in the general. I think I prefer to wait on some of these applications.
It's
I need
fine.
more time.
No, but we've also
Yeah.
spent a lot of time tonight on some big ones, so I think we made that is fair. We have time. Unless there's any discussion, I'd like to make a vote, hear the vote. All those in favor, please say aye or raise your hands. Passes unanimously. Commissioner Siebert in for this one. All right. Moving on to our public hearing, I'll call the 2 items for 65 Station Street. Application of SF Station Street LLC to rezone a portion of property to neighborhood design business district located at the southeasterly boundary of 65 Station Street on land presently zoned Residence A, special permit and coastal site plan application of SF Station Street LLC to construct a new 2-story, 6,842,000 square foot office building, associated parking shown on plans entitled Site Improvements for Proposed Office Building, Summit Development at 5588 August 1st, 2024, et cetera. Attorney Russo, good evening.
Chairman, members of the commission, good to be before you. Good evening. Chris Russo with
It's on.
Russo and Rizzio LLC, offices at 10 Saskell Hill Road, Fairfield. Here on behalf of the applicant, I'm here with David Ball, who's our architect, on the special permit site plan portion of the application. So as stated, we're here for 2 things: for the zone change application, which is to change the zone of a portion of the property. It's one property, but to change the portion of the property from the Residence A zone to the NDD zone. To show you that specifically to the zone change map. So the northern portion of the site, and this is just to orient you, this is Pequot Avenue. It would be right here.
We're showing it up on the screen as well, ladies and gentlemen.
Sorry.
Helps.
So what you see there on the screen to the north there above, which is kind of predominant there, is the train tracks. And Station Street. You can see over here on the eastern side of the site. To the west is Southport Congregational Church. I have an aerial. You can see it's mainly centered on their parking lot in the rear. There's a property here that you can see the bounds of that's located in the DRD. And then there's these dwellings where that's in the Residence A zone. So that's just to orient you. Pachi would be right over in this area to the east. And there's more NDD directly across the street from the site as well. So what we are looking to do is to rezone the southern portion. This portion is already in the NDD. It's where the existing buildings are located, as well as some of the parking. That area is almost about 32,000 square feet. The southern portion is in the Residence A zone. That's approximately 10,800 square feet. So it's predominantly in the NDD, but it's a split zone property. And we're looking to bring the entire site into the remaining 10,800 feet into the Residence A. Unifying the zoning designation.
Neighborhood design.
Neighborhood design, sorry, I might have misstated there, sorry. Yeah, for this into the neighborhood design. That would eliminate a existing non-conforming condition, which you could see here, which is that the our parking for commercial use is located in a residence zone. This is a long-established property, but the parking is currently in the Residence A zone. And so by locating it within the NDD, that would remove that nonconformity, and then there's site development beyond that that I will show you. But that's what we're proposing with the zone change. And again, remove this nonconformity. We believe the zone change application conforms with your plan of conservation and development. One, the POCD emphasized maintaining the integrity of the NDD. We think split zoning this property undermines that goal. It really NDBD, yeah, Neighborhood Design Business District. This piece has been one piece as far as back as I could find, and you know, split zone properties or something. If I ever came to you for an application where I was proposing a development or I was proposing a zone change, we wouldn't propose split zone. Those are generally not favored to do something split zoned. The residential A portion is no way conforming to the requirements for residential A. It has no frontage. It doesn't have the square. So it's not a conforming residential A piece. The POCD also discourages on-street parking and encourages the creation of off-street parking. I think that's particularly sensitive in Southport. And I think what you're gonna see in this application as I go through the whole application is it's not really about the development of the building that's proposed, because that's located entirely within the NDD portion of the site. But it's really about the parking and being able to physically provide a parking area here. But again, that's conforming. So making this conform, but then also proposing a conforming parking use to support the commercial property. Split zoning impairs that ability because commercial parking is not allowed in the residential A zone. One of the things I wanted to point out is just because I've talked with some neighbors. I met with the Sasquatch group of the Conservancy, who are always very generous with their time to meet with me. They got everybody together in the summer, had some people participate by Zoom. And there was some comments made, and I know they're gonna speak on the application, but they're about whether or not expanding this zone was allowing the building that we're proposing. And so this is venturing a little bit into the special permit site plan portion. But I want to make clear from the jump, even if we count only the portion of the site that is currently zoned NDBD, we have enough area within that specific area to locate the office building that we're proposing, both in terms of floor area and coverage. So it's not that expanding this zone is the only way to allow a building of that size in terms of coverage and FAR. So just for illustration, if you just used the current NDD portion of the site and included the proposed building, we'd have a little over 25% coverage. And the NDD allows 75% coverage. So even if we were to just restrict it to that site, we would still conform. And then for FAR, if you just use the NDD portion of the site and included the proposed building, we have an FAR of about 42% and the NDD allows 100% FAR. NDB,
That's fine, I know NDD is nearby as well, I think in this area, right?
Well, they're both, I interchange, and it's not DCD, it's not, but just, yeah, Neighborhood Design Business District, which I sometimes call an NDD, but yeah, so it's that building that you're gonna see in later plans could go on just the NDD portion. It's the fact that we're proposing parking that would occupy this area, plus the existing non-conforming parking that requires a zone change. So hope that makes sense. I could run through some of the numbers when they get to the zoning data table.
Talk to staff about the numbers.
Yeah, I mean, we submitted the application. I don't think there's no need for a variance or anything like that. But I'm just trying to lay out the point that it's not like we're proposing a 6,800 square foot building in terms of floor area. It's not like if we didn't have this portion, it would be 4,800 and we need the extra to get to 6,800. We already have the area for that. It's really just for the site to be entirely within one zone, which I think is what we aim for, and then allowing parking in this area. So, and I'll go through the zoning data table and lay that out. The zone change allows for the commercial uses to be properly supported by parking and eliminates the nonconformity. Again, if I was submitting a normal development application or a zone change application, I would not propose a split zone on a single property that's not favored in the P O C D. I also see there's language in the draft P O C D that talks against that and about eliminating split zones. And I think this existing can counter to what you have in your P O C D. The other thing I'll say too about this application as a whole is section Roman numeral 3.10 of the P O C D seeks balanced development across residential and commercial use. This application supports this goal by promoting, I think, necessary commercial development. There's obviously been a skew towards residential development in town recently. I think one of the nice things we're seeing in Southport, at least that I've been affiliated with, is it's been more balanced. And I think it's fulfilling that goal of the POCD better. We had 250 Pequot Avenue, which was approved to bring 18 units of residential. You have this application, which is proposing professional office, which I haven't seen a ton of professional office. It's good to see an application proposing some professional office in what I think is an appropriate location. There's a pending application to you for 95 Old Post Road, which is around the corner, which is proposing retail, office, and only 3 apartments. And then I know there's going to be an application for 204 Old Post Road, again around the corner, which is going to propose residential. So, you know, maybe in contrast to some other areas of town, in Southport at least, the ones I've been affiliated in, what I've seen, there's been much more of a balance between residential and commercial, which again is encouraged by your POCD. And this application, you know, certainly I think aims towards that goal. And I'll note again, I know it doesn't apply yet, but there is a section of your new POCD which discusses policies for economic development. And it specifically states to review the existing zoning map to reduce residential, commercial, and industrial split zone properties. So I think we're getting a jump on that P O C D with this application to make this a single zone. Beyond the P O C D, we think the site's appropriate for the entire site to be located in a neighborhood design district. One, it's got 2 street frontages in a commercial area. It's adjacent to the Southport train station. Is the Southport train station the downtown station of Fairfield Metro in terms of size? No, but it gets you on the same train. It's mass transit, and we obviously have commercial abutting our other train stations. It borders a church parking lot with a well-established nursery school. Both my children and I went there. It's been around quite a long time, but it is something where I do not feel our use and what we're proposing would have a negative impact on that use. It's opposite an existing NDBD parcel across Station Street. It's opposite another commercial use with the Pachi restaurant. And then obviously it's in close proximity to the Pequot Avenue commercial corridor. And importantly, another thing I want to point out, it's not a case of this property being a commercial encroachment into a purely residential area. It's not expanding the zone to a property that was known to be a residential property. And with that, I don't know if you have copies of it, I can hand them out. Just hold that line on. The history of the of this being the Ruger property.
Just give it to him. We'll pass it down.
You guys know?
Thank you.
You got it.
This is upload. I got it. I got it.
Yeah.
This has been uploaded already?
It's been uploaded. So in case you didn't have a copy, it's a copy. But this is the property where Ruger started making firearms, started in 1949. In fact, for their 75th anniversary, actually, they issued a pistol, which was embossed with the word 75 Station Street, which was the address associated with this building right here in front. And it was actually red as a nod to the red barn that's there. So this site has a long history. It's a commercial industrial property. So with this requested zone change, it's not encroachment into new area. This is a well-established non-residential property. We're not acquiring new property and making it commercial. It's been this way. And then, you know, the most obvious reason for this site, I think, to be zoned fully NDD is it's already predominantly in the NDD. So if a portion of it is appropriate for NDD, really the entire parcel is, and your regulations have standards in them to ensure you have appropriately buffer residential uses, and those would apply to this property if it was zoned fully in the DBD.
Hey, neighbors, some of these pages are cut off. I'm not sure if,
In the full article, it might be, or they're ads, they're.
like some of the copy, I don't know if that's relevant to us, but it might be.
Yeah,
You just want to rescan it.
Yeah, maybe the printed version, it didn't copy all the print. Most of the pages, they're all there. But I do see a few where it might have cut off a picture or something.
Take a look later, please.
I will.
Thank you.
But you know, this is just what you can see. One of the pages, you can actually see the existing barn. It says, and that part isn't cut off. It's the part I wanted you to see. That the red barn, it's called the Red Barn at 75 Station Street in Southport, was where Ruger was based out of. But I'll take a look at the scan. So regarding the site development, switching to that. So going off of what I was saying earlier about this development, it's for a new office building in the corner of the property. Again, within the part that's currently NDBD, and that the proposed professional office use is conforming to that zone. But one of the things I wanted to point out is on this zoning data table. and specifically regarding, the maximum height for a building or structure and what we're proposing, because this is an extremely reasonable proposal. It's well within the standards. So the maximum height or even the Residence A district, so not the NDD, is 32 feet. And the proposed building is under 30. For maximum number of stories per building, in the A zone, not even the NDD zone, it's 2.5 stories. The NDBD zone, it's 3 stories. We're proposing 2 stories. So we're even under the residential A standards. For maximum building lot coverage, the Residence A zone is 20%. The NDBD zone is 75%, and we're proposing 19.10%. So we're below both the NDBD and the A zone. And then for maximum floor area as a percentage of lot area, Residence A has a maximum of 40%. The NDBD zone is a maximum of 100%. And we're proposing 31.4%. So obviously, we're requesting you to go to the NDBD standards, but I just wanted to point out, as far as what we're requesting here, it's not only below on these standards in particular, it's not only below the NDBD, it's also below the Residence A. And David's going to walk you through the design of his building that he's designed here, and I think you'll see it fits into the character of the existing buildings on the property, but also the neighborhood. So just to show you site plans, the entrance will remain as it is existing, which is off of Station Street. Not going to change that. What you can see is that we are proposing restriping this parking area, and you could see the outline in light gray of the old parking area, which goes to around here. We're proposing to flatten that along the entire stretch. So you'd have parking right along here, and then into a new parking area, which would support the newly proposed building, which again is around 6,800 square feet of floor area, that be located here in close proximity to the parking lot for Southport Congregational and the train tracks. You can see on here, there's 2 existing buildings. The barn that I was just talking about, which is the old Ruger barn, that's here right on the corner, close to the corner. And then there's that currently has there's a realtor's office in here. And then there's this building here that's, again, proposed to remain. That's a existing office building. And, you know, when David walks through his design, you'll see how he's matched that. But there's connectivity between the buildings, and there's a dumpster that's proposed in the middle of the site. The parking provided is sufficient under your regulations to support these buildings, so it'd be fully conforming to the parking. Sure.
That's in the bottom left corner.
This is an area David will show you on the plan, but this is in a landscaped area. It has some mature trees. There's some planting proposed here. There's also a retaining wall located right here. But this mainly, and you'll see it on the landscape plan that David's going to show you, would be mature trees and some new plantings there as well, to maintain a buffer to the residential. And then this just shows you one of the nice things when you redevelop property, especially property that's you know, as old as this property is to add some additional drainage and make sure that this property is up to current drainage codes, stormwater codes. With that, I think I'll hand it over to you, David, if you want to run through. I can put.
You have slides, bring up. Thank you, Mr. Bowen.
Chris, do we have those renderings?
Yeah, they should have been in the architectural. They might be in different order. It's the only thing.
We're good with it.
Okay.
So I think. So good evening, David Ball. I'm the principal of the Monroe Partnership. We're located in Norwalk, Connecticut on 8 Ninth Street. as Chris talked a little bit about, I apologize, I've got a bad leg, so I'm gonna.
Don't worry about it. Chris can
But
bring it over.
the basic layout of the site was to, number one, an extension of the existing office development. And so really respect the architecture that's there. I'm not gonna go into what style it is because there's different opinions, but it's, it's got a sense of barn, age. And so what we had tried different things along the way, but it really seemed to fit in very nicely to use that same style. It really all came together. And another very important thing was for the south, this is north, south, east, west. So the southwest corner has some very nice mature trees. And we met with the Historic District Commission a few times informally. And that was one thing that came up. And so, certainly agreed with them. If we could save that area of the site, it would do two things: preserve some great trees, and secondly, buffer between the neighbors. So what we really tried to do is place the building essentially as far away from the neighbors as possible. So it's, quite close to the corner, and it's adjacent to the church parking lot. So you could flip the slide. This is really. Yeah. So this top left slide is probably the best reflection of what the building will look like. And again, it's the same colors, same roof lines, same windows. And I'll get into a little bit more detail about that. But this is perhaps the most visible portion of the building. And as you go around, the site, this is, from the northwest, you're looking, that's adjacent to the railroad. And basically, by the way, there's a bit of property that's either owned by the town or by the railroad that we would work with them to improve the landscaping, because now it's kind of overgrown with wild bushes and so on. This would be from the southwest, more or less from the church parking lot. And we would add screening along that area, even though we think the building's worth seeing, but they may have a different opinion about that. And again, that's from the southeast. So there's quite a bit of existing and proposed screening around the property. And I think the next slide is kind of the same thing, is just taking views from, what you'd see from the surrounding neighborhood. So along the south, there's some existing walls, partly on our property, partly on neighboring properties, that act as screening, and we would keep the mature trees. This is kind of seeing that southwest corner. And I'm not going to get into all the detail, but you get a sense that the architecture, what we're proposing is very consistent with the architecture of the existing campus.
So, and just to point out, so Commissioner Braun, this is that area that you were pointing out. That's the mature area
When
here.
I look at an aerial, there's a lot of mature trees.
Yes.
You're losing some of
And
them.
we did our best to avoid them. And
How many are being retained versus cut?
there's probably 6 or 7, and we might have lost 1 or 2. It's that type of number.
Okay.
So we really, I actually personally did the site layout.
Mhm.
No offense to civil engineers, but you're really thinking about how do we make this the best it could be? And the other thing, in the slide that Chris pointed out, the parking does go pretty deeply into the site. We effectively, in fact, well, there's a slide here just to sort of show the surrounding architecture, which is got excellent character. And trying to mimic some of these buildings eventually didn't make sense. It really made more sense to mimic or respond to the existing architecture on the site. And then the site plan, again, here's, these tiny little dots, what you probably can't see, are the existing, or I beg your pardon, these trees here. And we're suggesting we put some more, new trees in there as well to fill up the space. But in general, the existing parking sort of stops about here. So we're just adding this to accommodate the extra square footage. Real quick, so you can see there's property here that is off of our property. So we'll work with whoever to, to clean that up. And then secondly, there's a fairly significant grade change. That's about 8 or 10 feet. Because this road kind of takes a dive to go under the bridge. Yeah, I'm good. And Chris already, I was gonna go through some of the zoning regs, but basically we're well below what's required. This is just sort of a black and white that talks about the, the setbacks and all that. And then, so the building, basic floor plan is very simple. And these are about to crash, but that's okay.
That's fine.
So I've done lots of office buildings in my career, Duracell headquarters. I started my career at IBM. I just really know office buildings. And when we laid out the building, what's really important is you say, well, how would they fit this up? So we're showing off, private offices here and here. And in the middle would be some sort of open bullpen. There's a lot of trading desks these days and that sort of thing. And so really think about, make sure there's windows for each of these offices, make sure there's enough width to make the overall space work. And the other thing that we did, which is a little bit different than the architecture of the existing site, which tends to be punch windows and barns. This has got substantial windows at the ends. And in the renderings, it seems to make sense, but this for the open office area, you've got nice windows at each end. And then, the entrance, a stair, an elevator, and a restroom. The second floor is essentially the same plan, so we could skip over that. And then I just wanted to point out one thing about the roof plan is that the mechanical systems, there would be rooftop units here in the middle of essentially a flat roof. They would not be visible at all to anybody around the property. And then the elevations, first talked about the height, it's 2 stories, it's 26 feet 4 inches and change. And again, the architecture is responding to the barn-like architecture of the site. The end elevation you see, which you only see glimpses of it from the site or from around, but there's a fair amount of window there. We do have a porch, an open porch on the second floor, and on the first floor, that's at the west end of the building, be just a nice place to set out. And if your boss is not watching, go on the internet or something like that.
So this faces the church.
That faces the church. This is the front of the building, which is facing south to the parking lot. And then the other 2 elevations are effectively the same. And, that's a very simple, straightforward barn-like sort of mill building type of architecture. And then really quick, the landscaping we talked about, and, we'll certainly work with you folks about, saving the trees the best we can. And secondly, adding screen trees along the edges so that, there's separation between the neighbors and our site. So one last thing I'll bring up is the lighting. The existing site only has lights. Well, let's just put the front one up. So the existing buildings only have lights which are required by code, but something like these at the entrances. We are not doing pole lights in the parking lot. And then in addition to that, you're gonna have a hard time seeing, we submitted these, but there's motion sensor type lights sort of underneath the eaves of the buildings, just, at nighttime. So in general, the lighting would look more like a house than a commercial development.
And I think I noted this, but this is located in a historic district, so this would have to go through Historic District Commission. That's kind of gone into our thoughts about the lighting and having limited lighting and matching what's already existing on the other buildings. But we had a pre-app with Historic District Commission to review this proposal and how we're laying out to get some feedback from that.
Do you have trees in the parking lot, like the?
Yeah, there would be a tree, well, Right, sorry.
Like it follows our regulation for 1 tree for every what,
Yeah.
10 spaces?
So there's trees, there's peninsulas or islands, whatever you want to call them, to meet those regulations.
Yeah, and this is our longest stretch right here, and that would require the tree island.
Yes.
And so you can see it there on the plan.
Right.
But there's also one over here as well.
I have some questions. I'm sorry, other commissioners have questions. Is there anything else where you need for your presentation?
I think there's a couple remaining things to go through, but if there's any questions for the architect.
Harrison Levy.
Yeah, thank you. Just one of my biggest pet peeves in town is lights being on in offices after hours when no one is in the office. You know, we see it everywhere. I would just want to ensure that that is not going to be the case here. So I don't want these lights to be on, because they'll just be as kind of obscene
protruding
as
into.
parking lot lights can be.
We could certainly put them on timers. And so, but, sorry, we could put them on timers. And, certainly in the winter time, you have them on to, let's say, 7 or 8 o'clock at
Well,
night,
of course,
but that we certainly can do
I'm
that.
making reasonable accommodations. I think it's fair. I just wouldn't want these on at midnight on a Saturday night.
Right.
100%.
Thank you.
Commissioner Levy.
Yeah, along the southern boundary between the A zone and the parking, is there fencing or trees, that long stretch?
So southern boundary has an existing brick wall for a good part of it, and then it turns into, and arguably it's the neighbor's wall, even though I think the surveys indicated slightly onto this property, but, and then there's a wood black fence, vertical slats. So for most of the property, there's existing fence, solid.
Is that about 6 feet high or?
Yeah, it's fairly high. Yeah.
Thank you.
What's currently in the residence A zone, what's the current conditions? Is it parking lot?
Right now it's
Just
parking.
parking.
Yeah,
That's what want to keep it as.
want to keep it as parking, yes, and expand the parking area. But as far as improvements, let's go back to the site.
The dash line.
So,
Oh, you go.
well, so the existing parking is in the light gray, it basically ends around here, so we're just slightly, and then it continues, so you can see it here, because it comes in and then it comes across,
It goes up.
and it goes up
How
there.
many new parking spots are you adding?
So there's 37 now, and we're adding an additional 16 or 17.
I assume you need those 17 for the building.
So for this
To
building,
meet the 1 for 250.
All right, and you couldn't otherwise put the parking there if it's in residence A?
can't put it in residence A because it's commercial parking, support of the commercial
That's
use.
fine. I just want, by all accounts, then you do need the zone change in order for this project to.
In order for the parking, correct. What I was trying to point out earlier is
No, no,
just the size of the building.
No, you're right, and I'm not suggesting that that's wrong. I'm trying to understand the importance or the need for the zone change.
Right.
There is a need practically for it. Got it.
Yes.
Go ahead.
Well, and I'll just point out too that, there are provisions in your regulations that would protect a residence, it's a 10-foot setback to a residence district. So you have in your regulations buffers already built in for that type of situation, but we'll also, we're proposing it with it, but we'd be happy to accept a condition of approval that the building specifically be located in this location, which is, as David was saying, as far away as we could possibly locate it from the residential.
But that's the application is where it is.
There, I don't think there's real need, but I just want to make clear, that's where it's going. It's not being, it can't be shifted over.
Anything else in your presentation? Hold on. Anything else in your presentation?
No, that's it. Again, I was just gonna restate, which I've already done really, but is that we think it's an extremely reasonable application when you look at zoning standards and what's allowed from a coverage and an FAR point of view. And this use is already existing on the site, so it's not like we're proposing a different use than what's already there. And we're rectifying a split zone, which is something that this commission has always kind of, not been in favor of split zoning. It's a general principle to stay away from split zoning. I think this application corrects that, that current existing issue on the site. Relocates it.
There's
Answer
a
any other
couple of
questions?
trees on the other corner there. next to
Sorry?
the New building. There's a couple of trees in that corner of the lot next to the new building, like the corner, yeah, right. Are you preserving any of those mature trees?
Certainly if we can.
And there's some, I think, that are in this area that's off the property. There are
Yeah,
some
that's
mature trees.
fairly
I will
heavily.
say, but the problem is there's some, I think, overgrown shrubs on that portion that need some TLC, which we'll be happy to work with, who we need to work with to get that trimmed.
Commissioner Randolph?
Yeah, three categories of questions. The favorites, parking, lighting, and trees. So I'll start with the easy one. Lighting, our regs require full cutoff fixtures. Will these lighting fixtures comply with that?
The answer is yes. These lights that we brought tonight and submitted earlier, I think would not quite meet that requirement. We did this to match the existing, but we are well aware of the cutoff requirements, so we would change them out if need be.
So they will be full cutoffs.
Yeah.
We'll really full cut off, and the design will have to be signed off by HTC.
Make that a condition.
You can make it a conditions.
So
Just because I see
those-
those at the time.
Yeah, so also for the lighting, I didn't see a lighting plan for light trespass.
We can provide that. I mean, we've got light at the entrances. We do not have it in the parking lot.
No parking lot lighting?
No.
Okay. Trees. So it looked like, I didn't see a survey of the existing trees. Would you be open to replacing at 150% of the elimination of caliper inch of the trees you're removing? Because we're removing some pretty significant trees from a historic section of town.
Explain that.
So for every caliper inch, a standard is to replace it with 150, 1.5 caliper inches. So in other parts of the town, so you can't fit them all here, but we have other parts of the town that need trees to replenish the tree canopy.
So Commissioner, you're saying if we couldn't accommodate it on the site, we could accommodate it in other areas of town, we'd be happy to do that as a condition. Okay.
And to be clear, we're talking about, I mean, the caliper of these trees might be 18 inches. They're
Yes.
substantial trees.
Yes.
And so you do a series
Smaller
of 6
tree,
inches or
smaller
whatever to accommodate that.
Yeah. Yeah. That's a request.
Yeah, happy to accept that.
And then for parking, you said 1 per 250. I know this is a controversial topic, but Fairfield is grossly overparked. It's changed. Have you considered doing a parking plan? You're right by the train station. Some people might be coming by train. Had you looked at reducing potentially your incremental 17 parking spaces?
We follow the regs, but we're happy to consider, or, what we could do is future.
I'm just not aware if there's a mechanism in the regulations without a mix of uses where we could reduce that requirement. I think you would need the mix with residential to be able to do that.
At this present time, yes.
At this present time, yes. Stay tuned.
Stay tuned.
If that would, it's something that some of the commissioners would consider because we have way too much impermeable surface of this town. They're in a sensitive area of town but it's something just as a consideration.
Yes, number one, the nature of office use these days because of COVID and it's less parked than it used to be. So that is an issue that we consider. And one thing we might do is say, let's try moving it back 2 or 3 spaces and see how it works. And if it turns out we need more, then we fill them in.
Let's leave it there because again, I don't know if we have anything in our regulations that allow for that kind of a mechanism.
No, but not yet, but I'm asking if that is something you could potentially provide to have more trees and less asphalt. Because as we know, working on office buildings, parking is grossly underutilized.
Right.
So.
Sure.
I think if you look at the site existing conditions, it's, the parking area is not used anywhere near to.
No, it's
capacity.
probably half parked.
Right.
But there's some tenants that are kind of not showing up.
Let's leave it there. Any other questions? Anything else?
That's it for now. I'll run through the standards after, public.
So that's fine because our curfew is 10 o'clock, but I want to get to public comment. So I'll end the initial presentation portion of this application and turn it over to public comment. Attorney Green, you have, I imagine, clients. How long do you have your presentation to be, you think?
Thank you, Mr. Chairman. I have a pretty lengthy presentation, and I would note that public has sat here, I think, a lot longer than they may have expected. I know that there are a number of people who wish to address the commission on this
All
application.
right, why don't I do public comment and we'll see how far we get at a certain point. So ladies and gentlemen, I'll open it up to public comments. The idea is it's gonna be a first come, first serve. The rush, obviously, we'll do our best to kind of get a queue going. When you get up here, if you can please state your name and address for the record, keep comments germane to the issue. One thing I'll say, I don't think we'll finish tonight. I'm gonna guess we're not gonna finish tonight. One of the things we do accept is written comments via email, which I find to be very helpful because I can go back and read them. We're limiting public comment to 3 minutes in person. If emails can go on 3, 4, 5 pages, so you can say a little bit more. They're of equal weight. I read them. I know my colleagues read them as well. So feel free to come up and speak. Like I said, 3 minutes. This is a 3 minutes timer. We don't finish. You don't get to everything you wanted to say. You can always supplement by writing, or you can choose to submit in writing anyways. As I said, we read it all.
Mr. Chairman, can I, if you would just indulge me for 1 minute, I do have something that I would like to do, and for the record, just for the record at this moment, my name is Joel Green. I practice law in Bridgeport, the law offices of Green and Gross. I have been retained by a number of individuals who reside on properties that are abut or on Station Street or are in the immediate neighborhood. But I know so many people have shown up tonight and they've all been here, as the commission recognizes, for almost 3 hours. And one of the things I was hoping to do in order to maybe some residents won't feel the need necessarily to speak is to ask those in opposition to stand. I can do it in the context of my presentation, but I fear that some of these.
No, that's fine. Well,
So-
I mean, and even there could be people who are not here tonight that want to submit in writing, which is fine too.
So
go
I would just do that. So
Just give me hands if you feel.
preliminary to my presentation, I would just ask that anyone who is here from the Southport community in opposition to these applications, if you would kindly raise your hands or stand would be great.
That's fine. No, that's what I was, to be honest, somewhat expecting.
I just wanted to, I said that I would do that, and I didn't want folks who do speak tonight to necessarily have to appear next week for this.
No, that's fine. All right, so,
With that, I would propose to delay my presentation. We'll see how public comment goes. I can start this evening or I can not, but I know a lot of people.
well, and the other thing I would say is this, if you've retained Attorney Green, if I could just, if you've retained Attorney Green, who I expect will give not simply lengthy, but a thorough and presentation, I don't think you need to come up and speak in addition to him. Unless I'll leave that to you and your clients.
The only thing I think that's a great point. The only thing I would add is that some of these folks will provide an evidentiary basis for.
Fair enough. I just put that out there. I just don't want to be duplicative if we can. So why don't we get started? We'll start with in person. It's kind of first come, first served. Maybe we can just have people sign up in the back. Ma'am here and then ma'am there. And then we'll see where it goes from there. If you can just come up.
Here.
Feel free to sit or stand, use the microphone, please. Again, if you can just give your name and address.
Sure.
I am gonna keep it to 3 minutes. We've been doing that because of how much we have. And as I said, you can supplement anything in writing later.
Hear me, this is fine.
I don't think it's working.
It's not working.
Just go ahead.
Okay, I think everybody can hear me anyway.
I would still use the microphone. It helps us.
Okay,
Thank you very much.
My name is Lynn Plant, Evelyn Wynn on formal documents. I live on Pequot, on 504 and that little corner that's been.
Feel free to sit too,
discussed.
ma'am, if you want.
Yeah,
Stand or
I
sit,
will.
whatever you like. I'm sorry.
I have lengthy comments, but given the time frame, I really want to get through this. I'd like to vehemently oppose this project, which I think was stated as, the zoning change was sort of incidental, but I think the zoning changing from a residential area is removing a very, very important buffer in a very tiny enclave of neighbors. And I think that all of the issues that have come up, lighting, a motion sensor in a building on that property would detect me walking out on my deck. So it's very tight quarters. We have to keep the scale in mind of the neighborhood and of the proximity of this building if the setbacks change. And one thing that nobody addressed is that corner property. Someone mentioned that there was a 12-foot grade change in front of the property. Behind the property, from the parking lot, slopes down a good 12 feet. So that my 6-foot stockade fence, which is inside my property line, there's probably 6 feet of open space and then the level parking lot. So I don't really understand what's going to happen to change the grade of that particular property, which is where all the 100-year-old legacy trees are. There doesn't seem to be a site plan for the side of it. And I'm really, really concerned about removal of that copse of trees. I just want to read one quick thing that currently the residential zone in place that buffers the commercial property from my backyard consists largely of a steep embankment of legacy trees, hundreds of years old and hundreds of feet high. And this little bit of nature works really hard. The ground is permeable. It helps with runoff. It provides a natural green screen. It muffles sound, which is so critical. It provides privacy and it's habitat for birds, squirrels, and chipmunks. And so changing this from a buffer zone to something that potentially has a 10-foot setback, and how do we know what could happen, what could change to that property that would really dramatically impact my house and all of the homes on Pequot Avenue. And I just want to say one final thing, that is, I bought my house knowing there's a critical buffer zone protecting Pequot Court from extended commercial enterprise. In the same way that Mr. Charney bought 65 Station Street, knowing that any future property development, and he's put forth several plans, would need to comply with pre-existing zoning designations, as well as historic and restrictions. So I think, caveat emptor, he bought it, I bought it. Why would, his request to change residential zoning in his favor only
Ma'am, can you finish up, please?
will only be to his benefit, but add to the devaluation of my house? And I think I'm talking really up close and personal. I think a lot of people will have larger comments about the character of Southport at large. Thanks.
Thank you. If there's anything to supplement, please email it to us.
I have copies I can leave with you, including I took a photo of the distinction
Well,
in
that- yeah.
elevation.
Definitely leave that. All right, if this,
Emailed into the record?
no, they just brought it now, so I'm just asking her to submit it. If this is the order, that's fine. However you want to do it, come on up.
Thank you.
Sir, if you want to sit, I'll remember where your place in line is. It's up to you, though. So I'll remember his place in line if you want to talk.
Yes.
My name is Steve Stanton. I live at 560 Pequot Avenue. I am speaking in opposition to the plan. I think the reason is a zone change primarily, and try to give a little more color to my thoughts. I go back to your, Mr. Noonan, your comments about assume maximum build out to make a decision for this kind of move. Assuming its setback goes from 30 feet to 10 feet, assuming that the max building lot coverage goes from 25 to 75%, assuming that the floor area allowance goes from 40 to 100%. I think that has to be the basis upon which I think this should be decided. There's no denying that the zone change would make our community more vulnerable and less able to resist this type of development or this type of project. As much as the split zone protocol is not desirable, I get that, but it's all that we have. And that's one of our last bulwarks of resistance we have to this plan. So I think the threshold should be high to get this done. I think Chris and company have done some work to mitigate some of the effects of this, but the precedent is there. And I think that's the big problem with this plan. And beyond that, I think consistency is an issue here. The town has already conceded and agreed that this specific area is currently hazardous to both pedestrians and moving traffic, vehicular traffic. It's approved the installation of a significant plan, including a traffic island to remedy an already dangerous intersection at Station Street, Pequot and Chester Place. It doesn't make a lot of sense. The logic defies me that you're going to both agree that that's an issue of remedying that issue, and yet you're perhaps allowing a project that would then worsen traffic in this area. And my last comment, and I'll be brief, is your environmental concern. If Ruger indeed, which was producing firearms in this site, I'd love to see the effect of which, to the extent to which the soil makeup or the soil issues are a problem for this site. That area is rife with wetlands. Water has made its way in that area with every great rainfall, and to the extent to which that soil is a problem, that's going to be a problem for all of us and our neighbors. So I'd love to see that mitigated, and I think the burden should be on the proposal, those that are proposing this, to resolve that issue. And for those reasons, I'm in opposition.
Thank you. Okay. Again, feel free to supplement anything.
Yeah.
Hi, I'm Judy Proctor, live at 48 Pequot Avenue, the corner of Pequot and Station Street. There are lots of concerns about traffic and water runoff and PCBs. And the fact really that the purpose of this building will not serve our community as I understand neighborhood design business district should. So that diminishes our residential fabric. But for me, the most important is the zone change precedent this is going to set. Property next to ours between the post office and our house is currently split zone, residential A and neighborhood design business district. And would this set a precedent for that property being changed? I don't know. It's a big question. And as you may know, this is at least the second proposal that Summit has brought before the TP&Z. 7 years ago in 2018, he proposed a building that was 3,440 square feet. This current building is 6,842. The TP&Z denied that proposal. And here specifically is why. He was not asking for this residential zone change. So this is what the TP&Z voted at that time, that the use is inconsistent with the neighborhood design business district and the standards for issuance of a special permit. And that the purpose of emergency turnaround for fire trucks and emergency responders serving a commercial use is actually located in a residential zoned portion of the subject site. So clearly he does need to make this zone change in order to accommodate this building. This building is going to be 3,400 square feet larger than his last plan. And how does it meet the use of neighborhood design business district? So thank you for your opposition.
Thank you.
Good evening.
Good evening. My name is Christine Ford. My husband and I live with our 19-month-old son, kitty corner and across the street from where this proposed zone change and development is. And as the mother of a young child who's constantly trying to stop her son from running into the street and getting into trouble, I'm extremely concerned about this proposal for several reasons. Number one, increased vehicular traffic. This road is a pedestrian thoroughfare today. People of all ages are rushing to and from the train or just enjoying a leisurely stroll. There are people of all ages, including myself with my child in a stroller, and I've already had nearly several run-ins. We've talked about what has been, I understand the crosswalk that we're trying to get put in place at the end of Station Street. But the idea that there's a single entry and exit point, then there's going to be 50% more traffic going through that point is very scary to me. There's hardly enough room today for emergency vehicles to get by. If there was a car or a landscaping vehicle parked along the street, which frequently there is. And so further congestion, in my view, is really an accident waiting to happen. As I said, but we've nearly, people don't honk their horns when they go under the railroad, which they're supposed to, right? When they go under the railroad tracks. And moreover, there are limited crosswalks. Right? They're not all of Station Street has crosswalks. So that's my number one reason of real concern is I think this is an accident waiting to happen if we allow more vehicular traffic. Also, there's a potential environmental impact, which some of us have talked. It's my understanding that the parking lot is on top of where there used to be a gun manufacturing facility, right? So what potential pollutants are in there that could be released with construction with a completely unknown impact to residents, wetlands, and the general environment writ large from runoff, not to mention if my child's playing, and it's selfish, but for others who may live in areas where that rainwater could go down, we just don't know. A permanent conversion to commercial can't be undone, as we know. And as we've talked about, when this property was bought, it was known that it was a split property. And I think people talk to the historical integrity of the town. This is the entrance to the village. You're putting in a large building that materially changes the landscape in a way that cannot be taken back. General disruption to the neighborhood from construction, the scale, scope, the machinery, got real concerns around that, and it will have absolutely no benefit to the surrounding properties, residential properties, and the potential impact for decreased property values if you suddenly now are living across from an even larger parking lot. And so for all those reasons, and I would also highlight lighting concerns, because the lights today shine into our second floor windows, into our bedrooms. And we've had to go over and ask them to turn them down and turn them off. So that exists today before we increase the size of the building. So for all of those reasons, but particularly the potential safety hazards, I'm kindly asking you to please consider denying this requested zoning change and this proposed development. And I have emailed these comments. Hopefully you've gotten them. If not, I will resend them tomorrow. Thank you.
You. Good evening.
Good evening, I'm Jim Bohan, and we live, Eileen and I live in the.
Your time, no rush.
Thank you. Eileen and I are privileged to live on Station Street adjacent to this property. We have lived there since 1981, so can you speak up just a little bit? 40 years. Southport is among the most beautiful places on earth. I think we can all agree with that. The proposal for 65 Station Street converts mixed residential and commercial into fully commercial. adds parking, adds traffic, exacerbates the risks at the Station Street with what Avenue intersection. The town acknowledges there are hazards there and plans a traffic island, an island on Station Street at the foot of Station Street, right after you make the turn from Pequot Avenue. Plans a traffic island to address. It makes no sense to approve more parking, more traffic, while redesigning and rebuilding an intersection to address the traffic that's already there right now without those increased 17 parking. That's number one. Number two, in June 2007, Station Street property owners petitioned you, Town Planning and Zoning Commission, to designate Station Street Connecticut State Scenic Road, which the statute describes, bordered by mature trees or stone walls offering scenic views. It's a Connecticut Scenic Road. Station Street is a Connecticut Scenic Road. You granted scenic road status on August 30th, 2007, 18 years ago. 7 years later, our Chester Place neighbors across Pequot Avenue, they did the same thing. So what we have is a safe, secure, unbroken, continuous pedestrian path from the eastbound train station, which is, as Southport Conservative says, is a gateway to Southport Village. And anyone coming out from New York on the train, that's the gateway to Southport Village, that eastbound train station. That's the first thing you see. The point is, we and the Chester Place neighbors said we wanted to preserve this as a scenic road. So you could go from Gateway to Southport Village, down Station Street, across Pequot Road, down scenic Chester Place, which is a jewel, an absolute jewel, to our Main Street and our harbor. Commissioners, many thanks for those designations. I'm grateful to your forebears for accomplishing that. Very important. And the street signs labeling those two roads, scenic roads, are neat too. So thank you for those, but don't jam it. You go to work with a big parking. You know, you can stand anywhere in Southport Village. Stand anywhere. Pick your spot. Look around. And ask yourself, could it be any better? I think the answer is no. And how do we get that? We got there from restraint. When you have perfection, you preserve it. You're the stewards of, the Town Planning and Zoning Commissioners, the stewards of this incredible legacy. So please reject this proposal and protect the zoning balance that keeps our extraordinary village what it is. Again, thank you very much for your service. And I hope I haven't used up my 3 minutes.
A little over. Thank you. If nobody else, I wouldn't mind going to Attorney Green, but no, that's not the last chance, so to speak.
It is or is it not?
It is not, because I suspect we're not gonna finish tonight. After he's done, I'll open it up. Well, it's gonna remain open, but other members of the public can speak. Not those who've already spoken, please. No bites, second bites of the apple. I don't see anybody else. So why don't you, Attorney Green, come on up?
I don't know if there's online.
No, we'll go in person though. No,
Fine.
we always go in person, so that was a good time, I think, after 5 public. Attorney Green for the remainder of the our night. And again, our curfew is at 10 o'clock. We're gonna keep to that, considering, as I said earlier, busy and how frequently we've been meeting.
We get the site plan up on the screen. Site layout plan.
Green, how long do you think you have, though?
I don't know. Probably half hour, 40 minutes. I don't.
I'm not expecting, if you're not gonna finish tonight, that's fine, but I want to get a sense of how long. If you told me more than an hour, I was gonna be a little disappointed.
No.
You should be in an hour.
Once again, just for the record, Joel Green representing the following residents: Jennifer Murphy, Devin Murphy, Judith Proctor, Charles Proctor, James Bohan, Eileen Bohan, Jarrett Ford, Christine Ford, Andrew Hoffman, Anik Plevin, Elizabeth Charlotte, Ann Shaw, Jane Sutherland, Evelyn Wynn, and the Southport Congregational Church. And these individuals include many abutters, and certainly you can see from the site plan and piece it together, but almost everyone in this neighborhood is deeply, deeply concerned with this application. And there are really three applications presented here. One is a zoning map amendment, one is a special permit, and last, there is a CAM approval. And as you've heard, and I presume you will hear going forward, these residents are deeply concerned with the impact of this on the historic character of this neighborhood. They are concerned with intensification. They, like all of us in Fairfield, are concerned with overdevelopment. Attorney Russo talked about the long history of this site, the long history for the Ruger plant, but this portion of the property has a long history of being residential, this corner of this property that is proposed to be rezoned. The neighbors are concerned with traffic. The neighbors are concerned with lighting. They are concerned with noise. They are concerned with nuisance that comes with commercial development. They are concerned with potential environmental issues from previous uses on this site before many of our regulations and protections, which have been adopted and I think are still on the books as of today, existed. They are concerned with the overall general commercialization of Southport Village, as you've heard. And this application presents sort of something different that I haven't been before the commission with in many, many months. And that is that the burden here is on the applicant, which is, I think we've all been reoriented somehow, but the applicant has to satisfy the commission that it meets the standards for each of these approvals. And that's refreshing these days. I am unclear, and maybe through you, Mr. Chairman, the applicant can confirm, and I think it would be helpful to the commission, whether this project involves, it's an office, but perhaps Mr. Ball or Mr. Russo can comment whether it looks to me like it's a office for a single user because it appears to have this open core area, and it doesn't seem to be laid out as something that would be for a mishmash of professional office tenants, but maybe the applicant can clarify that, because I think that would be of interest to the commission. And if
Something, I mean, public comment where you ask the question through me and he'll get.
I'm asking it through you, and I think it would certainly affect my presentation going forward, depending on the response.
Shortens it, I'll ask it, but normally with rebuttal, he gives it to you at the end. We're not gonna finish tonight. I'd ask him at the conclusion, see what he is next time.
Oh. Okay, all right. So I guess, I think it would be relevant right now, and I appreciate your response, and I don't want to take up a lot of time, but certainly the commission, as part of these applications, has to find that this application meets the neighborhood design business district standards. 12.5 says, and it's right in the initial language, and we've addressed this many times over the years, but the purpose of the district, once again, and I'll read it, is to provide local neighborhoods with needed and desirable convenience goods and services in a manner that will not be detrimental to the surrounding residential areas. And once again, the uses permitted in this zone shall be limited to those which will primarily serve the local neighborhood and are consistent with the purpose for which the district was designed. And the applicant didn't cover that in their presentation. So certainly that puts me at a disadvantage in, I guess, addressing that, but that issue is out there.
I mean, as you said, I didn't escape me either, but he's got the burden.
Okay, all right.
I
well
just,
then-
that didn't escape me either, but it wasn't asked, it wasn't presented with the time and all that. I just, chose not to ask the question myself.
Well, so if there's new information submitted later, then we may wish to address that.
And Attorney Russo, I mean, is that something you want to respond to now, or is that something you want to talk offline? I'll let you. It was my initial thought that he can ask the question through me, you can give it to rebuttal. I will stick with that, but I'll let you make that decision right now, if that's okay.
He's saying section, I'm sorry, what are you saying, section?
12.5.
And what's the issue with 12.5? Sorry.
Well, I had asked whether this is going to be a collection of small tenants. Is it a single tenant, and what is it? So that we all know whether it, and the commission knows, frankly, whether it is consistent with the NDBD standard.
You're talking about 12.5.2.
Talking about 12.5, the initial language of regulation.
Well, if you're talking about the limit of the language of a single tenant, if somebody were to apply, if a tenant were to apply, they could not exceed 4,000 square feet.
Okay.
And if they did, they would need a variance.
Isn't there, and I'm sorry, just everything else going on, I just don't have it memorized. I thought the NBDD required limited what can be used, the property can be used for. I thought we had this, I thought we had the dispute, maybe not for this one, but in this area, about whether it was investment. It was used for investments or something like that, exclusive banking or something like that, and somewhere in Southport or NB.
I think the way that the regulations do it legally is by limiting the size of the tenancy in the building. So
Let me just,
12.5.
am I wrong in saying though that office uses are limited to what's prescribed in whatever the regulation is?
Right, so it would be limited to business and professional offices which primarily provide services to customers and clients on the premises, provided that no individual tenant shall have an interior floor area exceeding 4,000 square feet.
So his question, going against what I did, but that's fine. I guess his question is that first part with the uses, are the uses gonna be those predominantly given to people that are on site?
Correct.
But his question is, what's the use of the building?
We're requesting permission for a professional office which primarily provides services to customers and clients on the
Do
premises.
you know what the?
I don't know the specific user, but that's what the use we're requesting.
Okay, so you
Under
don't,
12.5.
you don't have an end user in
Correct.
mind.
Correct.
But it would have to. I guess the thought is whoever would come in as the potential end user would need to get a certificate of compliance. And we would have, if there is a dispute at that time, we will have to take it up at that time.
Yes, I would agree.
Okay. Got it? Yes.
Yeah, well, I'm not conceding
You don't have
that.
to concede it, but he doesn't have an end user. And whoever that end user is will have to comply with regulation. And I guess the end user that comes in is gonna have to get a certificate of compliance. And at that point, we're gonna know what the user is.
Okay. And I should ask one more question of the chair. Can we assume that this is the application at this point and it's not going to be, now that the public has spoken, that it's not going to be substantially new materials submitted, like by way of, in other words, if I point out infirmities in the application and missing information, proper rebuttal would be, no, it's submitted, here it is on the website, or here it is in our drawing, as opposed to, oh, this was missing information we should have required, now we're going to provide it on
I
rebuttal.
mean, if that comes up, that comes up, and I've thought I've been addressing that kind of issue pretty fairly as far as making sure that the record is fair and public comment is fair. But Commissioner Randolph, I think asked for something. That might be different,
That's different.
but I mean, if they give that a rebuttal, I mean, what do you want me to do at that point? It was asked by a commissioner.
Well,
So,
that's fine,
okay,
but I'm not asking for it. I'm pointing out that it doesn't exist in the application.
I get it. I mean,
In
listen,
other
if
words, we want to, as I always say, these are public hearings and not workshops. So we're not looking to fill in the blanks and help the applicant
yeah, I know.
design their application.
We've been doing this for, I've been doing this for 10 years and over a year right now. I know you're asking that because you're, of past experience. I have no control over that. The best I can do, if it's egregious, I'll keep it out, I think. But if it's not, then I will reopen public hearing like I have in the past.
Okay.
You've been in front of me long enough to kind of, I think, estimate kind of what I do.
Oh, yeah, no question about it, but sometimes,
No, let's just,
sometimes the commission has taken the position that the applicant has made its presentation and now the public is going to address it because public hearing is presentation. Public.
I've got no indication that,
And rebuttal.
yeah, and I don't mean to keep wasting time, but I've got no indication that anything's gonna change at this point.
Okay. So did I miss it in this application? Because sometimes I get confused with the sites. Sometimes if you look at the site, if you go into pending applications, you see one thing, and if you go in through the link on the agenda, you see another. But did I miss a traffic study here?
Traffic study.
So okay, let's talk about it then. How can the commission make findings, and this is preliminary, but as a preliminary matter, there are requirements for special permit, including impacts on traffic that the commission has to find, and specifically avoid undue traffic congestion from a proposed development. The applicant has been pretty vague so far tonight, as far as I'm concerned about what's going to be operating there, except that the tenant's going to be under 4,000 feet. I understand that we have parking requirements in Fairfield on office uses, but I don't know how the commission can make, for example, the findings required under 25.7.7 that says that there won't be undue traffic or congestion from the proposed special permit use. And it seems to me that in deciding whether to intensify the use of this property by converting it from a Residence A district, as it has historically been, this portion of the property, to an NDPD, that the commission would want to understand what the traffic impacts are. And you'll hear from members of the public tell you that Station Street is a busy street, especially starting this week with school in, and that there's a significant traffic issue on the street, and yet the applicant has not provided it. I'm surprised with a traffic study. And just to piggyback on that, I'm always faced, and the public is always faced, and as you've heard so many times, referenced by applicants' counsel to the McLaughlin decision, which is the case that Attorney Fallon has cited repeatedly to this commission as a response to general concerns by the public. In other words, when the public gets up and gives you anecdotal evidence about what's going on in a neighborhood, council always waives McLaughlin, and they say that general concerns don't count and you need substantial evidence under McLaughlin. And in this case, the applicant hasn't presented anything on traffic. So I would suggest that McLaughlin applies to an applicant just as it does to the public. And so that's a point. Similarly, under both 25.7 and under the special exception regulations in 27.4.2, the applicant hasn't provided any evidence on adequate access for fire protection. So that would conceivably be within a traffic study, I suppose, although I think Mr. Versteeg has frequently appeared before this commission and provided this commission with evidence on that. So the applicant, oh, by the way, and I guess I was incomplete earlier when I talked about 27.4.3, that which echoes the special permit, and this is special exception, which are incorporated by reference into the special permit standards, that the streets serving the proposed use shall be adequate to carry prospective traffic. Provision shall be made for entering and leaving the property without creating undue hazards to traffic or congestion. So I guess question becomes are we expecting, am I going to be confronted with a traffic study this week or next week, or will the commission submit that at this point? Or
I'll have to take it up when it comes up, because I don't know the answer to that, because we could reject it, be withdrawn. I mean,
could decide now, the commission could decide now.
Attorney Russo, come on up as well. In hearing the two issues, we'll leave my this, because this is. Are you intending to present a traffic report? Or
I'm going to rebut to comments and so, I mean, I'm gonna have a rebuttal. So if there's comments regarding traffic, I'll respond to them. And
are you gonna respond to them with the
I'll
next?
submit additional material. I mean, Attorney Green wants to keep it open, but he wants to only keep it open.
I know, but
mean, he's trying to get,
but there is, this is not unusual procedure, is initial presentation, all the evidence goes in that you need for your prima facie kind of presentation. Public comment goes underneath that, and then rebuttal stays within the public comment. But if you're gonna have a new traffic expert report, and rebuttal is new evidence.
So if that was to happen, I would submit new evidence prior to the hearing, and then Attorney Green says he's gonna continue his presentation to the next hearing, and then we respond to it. I mean, this commission frequently asks us for materials, and we come back with a response to it.
Yeah.
Some projects have requested for a traffic study, some projects in a design business district have not had a traffic study. We've proposed.
I don't think a traffic study is necessarily required.
Not for a special permit.
But there
This is a
is,
special permit application.
what is the I just don't recall, what is the element that we has to do with traffic with the special permit? Is it traffic congestion?
There's a bicycle and pedestrian plan required, but there's not specifically a traffic study required with a special permit application.
What's the standards for special permit?
In terms of making the findings?
Yes.
I mean, you do have to acknowledge whether or not there are impacts, and that can include looking at traffic.
But when it has to do with is there a burden on traffic?
Yeah.
What's the I just don't remember what the language is, I'm sorry.
Sorry, let me get that for you.
And 27.
And I'm not sure if I recall this, we need a pedestrian bike plan for this?
25.7.7 refers to last sentence. It begins with the development shown on the site plan. It says, shown on the site shall be of such character as to harmonize with the neighborhood to accomplish the transition between areas of unlike character. Then it goes on to say to avoid undue traffic congestion. And 27.4 is more specific, which is incorporated by the special permit. It says streets serving the proposed use shall be adequate to carry prospective traffic. Provision shall be made for entering and leaving the property without creating undue hazard to traffic or congestion. And what I was saying is under McLaughlin, the burden, you must produce substantial evidence. And substantial evidence to make those findings is usually interpreted to be expert testimony. That hasn't been provided. And my sense of what proper rebuttal is no, Attorney Green, either you missed the traffic study, we covered it here, but when I point out that it's not in the application, it's not a workshop where the applicant can go out now and commission a traffic study and come running in next week and I'm out. This is,
Well, I mean, listen,
gotta be fair.
well, and it's fair if I reopen the public comment to address those things. It's annoying because it kind of wastes time and resources at the same time. But, I mean, listen, we can go through this in our rebuttal. He sees the error of his ways and withdraws the application too. So, I mean, it's fine. Well, I mean, it's fine, except we're all back here kind of doing the same thing. I guess it's fine. That's what we're up here for. I mean, Attorney Russo, I guess if your thought is that your rebuttal is going to include an expert opinion, I think that's initial presentation materials.
But it's responding to comments were, you know, what the requirements for approval in 25.7 says is that the proposed use of building structures conforms to the standards applicable in the district. And we've presented an application that is conforming to the standards that you have in the regulations. Now, I'm always happy if the committee
Was though, it has to show, one of the things I have to show, find is an undue burden on traffic congestion. That's a finding I need to make.
right, and we don't think we have an impact on traffic, but there's nothing in here that says I'm required to submit for a special permit a traffic study and that the decision is, but what I'm saying is if the commission says to me, we have a concern about traffic, well, then I could go have somebody look at
No,
it.
but I think, no, I mean, maybe for an 830G, but I only want to go to there. But I'm just thinking just in general kind of litigation stuff is if you have a burden to prove, and I think that's your burden. I mean, you have to tell me, you disagree that that's not a burden you need to prove?
Well, that I satisfy the standards as listed in 25.7.
Exactly. You have to satisfy the standards. So, I mean, if you don't have evidence, and I don't know if like a silence of evidence means that there is no congestion. I don't think I can go that far. I need evidence. And if it's not a traffic report per se, it's some kind of testimony from, I guess, whomever. I mean, it could be, normally it's an expert, but I guess it could be a neighbor or two or the applicant who lives there or whatever the case may be. But I mean, if your thought is,
And I have the engineer respond to it who worked on it. I can have them respond to it. And they laid out the site, regard to the fire access issues. I mean, so I'll have the engineer respond to it.
That's an expert.
I know that, but I'm trying to see.
Just you didn't bring an expert in to start with.
I know, and that's the problem. I just. Excuse me, ma'am, please. I mean, all I'm gonna be doing at best case scenario is just reopening stuff and having them. Having the expert, have the public re-testify about things that you bring in that are completely new. So,
And retain our expert.
and then potentially retain, I'm not sure.
Well, it's limited to new evidence.
But that new evidence is gonna be the expert report.
Right. If they submit something before the next hearing.
Are you gonna submit something for the next hearing?
I mean, I have to talk to my client and review on the, based on what's being
I think
requested.
all right,
Along with the photometric
let me
and,
put it this way. I would think, I'm not gonna think, this is my position is gonna be, if you're presenting something new in the form of expert opinion.
Yeah.
First time in rebuttal, I am at the very least gonna open it up to public comment again.
oh, yeah, certainly, yeah.
Well, I know, but we shouldn't have to do that though. I mean, that should have been, I think, presented in the initial presentation. And
It's a requirement. I mean, I have not seen that every single special permit application that's been submitted to you has had to submit a traffic study.
put the study aside. I need evidence with respect to traffic. The study may not be required, I understand that, but I need evidence to show whether there is not, in your case, undue traffic congestion. And the few times that we've not done that, it's because, the commission, I think in these instances can use its regular judgment as members of the public in knowing what the streets are. But that's normally a very rare exception to the rule and not one that requires like a particular area of Southport as opposed to maybe Main Street or Black Rock Turnpike that everybody's familiar with. I don't know if everybody's familiar with that area. I'm not sure that I am. So, and if there's anything else that you're gonna need to submit to rebut, I mean, you know what they're, we're all seasoned, you're seasoned professionals, you know what each other is gonna say at this point. You've been talking with each other or all that. So if there's anything else that you're gonna present, I think the time is now. I don't wanna have to reopen it. I've never had to really exclude anything at rebuttal because the simple response is, well, I'll just withdraw and reapply, and that's just a waste of everybody's time and resources. So we're not gonna be here next week. We're way past our curfew. We're not here next week because next week is our P O C D and I want that meeting for our full attention on that for public comments. So at the very least, this is gonna be the next in 2 weeks, right? It brings us to 16th.
Yes, correct.
I mean, I guess the thought is, I mean, notice is somewhat given that if you're gonna require expert opinion in rebuttal, need it now. And I think even for traffic, I think at this point, I would go under the assumption that I think there should be some evidence that's given at this point. If you're gonna do that, because if you're not gonna do it in rebuttal, it's by definition new evidence because you didn't give it in the presentation.
I should just formally note my objection for the record.
No, I know. I mean, you're not wrong on what you said. I just, I come to rebuttal, having this fight with Attorney Russo. And I mean, he just says, well, if that's the case, I don't want a denial. I'll just withdraw the application.
Okay.
Well, I'm sure,
It would be a more orderly process if he did.
well, I think we can solve it now because if we do it in rebuttal, and he withdraws, I'm gonna guess he's gonna come back again. And I really don't want to waste time and resources.
I mean, if that's saying is now, it's, required to have a traffic study, then we would.
It's not, I'll say it one more time. I'm not requiring a traffic study. But I'm saying to you that if there are certain elements that we need to find, that's your burden to prove.
Right, and I would have to establish them at.
You have to present the evidence at the initial presentation.
I guess the part I'm struggling with is there's some evidence I'm allowed to submit, but there's not other evidence that I'm allowed to submit.
Say again, I'm sorry.
That there's some evidence I'm allowed to submit, but then there's other evidence that I'm not allowed to submit. And that's the part where I'm struggling with. And I'm not trying to be combative about it, but I'm kind of.
Let me say
trying
this.
to react in real time.
But I'm coming at this as a former litigator where the plaintiff has a burden of proving four elements. And you need to prove those 4 elements, negligence, for example, on your initial presentation. If you miss something and you realize it during the defense, you are not gonna have a chance necessarily to get it under rebuttal unless there is something up on your initial presentation that opens the door for that somehow. So that's the same framework I've been working on because public has a right to respond to your presentation. And if your initial presentation doesn't have, and to be fair, there isn't any evidence as to traffic, doesn't have to be a study. I agree, because I don't think there's a requirement in the regulations for an actual study.
Right.
But there is a requirement, I think, for evidence for us to make a finding.
Prima facie case.
Exactly, yes. So that's the nuanced distinction I'm making here.
Well, if that's what the commission's gonna hold, then I either have the decision of I'll just go on based on what I've submitted so far, or I can withdraw and I'll resubmit.
Or you can, I guess, rectify it and I just have to reopen it for, I don't know, we'll have to figure that out, because if we run up the time timeframe stuff, then
Well, I think we have, on this one, I think we have plenty of
I
time.
don't know the answer.
Time,
I'm
but-
just
but-
used to the
but-
fact that we're up against the gun, so who knows? But he needs to have time to review. Public needs to have time to review and respond. So in many cases, I may very well, the 4 or 5 people that spoke, they're gonna have a chance to come back, to talk about whatever you whatever you provided to us.
Right.
But again, because we've gone through this exercise, if on rebuttal, you're presenting something that's completely and wholly new.
Mhm.
I don't know what I'm gonna do at that point because I don't know what it is, but I'm gonna reserve the potential right to do something I've not done, and that's exclude evidence. And at that point, I mean, I'll talk to you, Attorney Green, about that too, because his response to that likely is gonna be withdrawal.
Right.
Maybe you're okay with that.
Well, I've also, I think,
I'm kind of-
I've always, when Attorney Green's needed extra time to review something, I have granted that time.
Well, we're
to
not,
do that. And when Attorney
we're not
Green
there
has
yet.
had experts that haven't shown up
Yeah.
for a meeting on
Oh.
time, I've also.
we're not there yet.
extended
We're not there. No, that's okay. We're not there yet. It's 10:15. It's 10:15. I don't wanna go crazy with it, but I mean, I will say I don't feel the need to waste not just the public's time, but I mean, more selfishly, our time, having been here once a week for a year. Okay, I mean, that's more of the concern, not that rights of the public aren't a concern to me, but you know, this is a year in the process of sitting here, so I really don't want to reopen public comment if I don't have to, and there's times we've had to do it. You both seen me do it and known when it has to do, but this is a little more like it's a little more unnecessary, maybe. Yes, I don't know. Maybe that's a strong word considering the time hour, but I'm just tired, so the synonym is not coming to me. All right, so I'm going to adjourn the meeting. It'll reconvene September 16th. We're gonna have an expert. I mean, I don't think I can get you, I don't know.
Mr. Chairman, do we done with?
No, not yet, I'm sorry. I should put a time limit on you, but I don't know how long you're gonna need. And I don't wanna put a time limit on you, go a day or two later, and then put him in a bind. So can I ask you guys to do something a little different? Convene on this, report back to staff Friday. Tell me, it's gonna be a joint, I'll make it a joint submittal, I guess. No, I won't. Attorney Russo, just respond back, copy to it at the same time, but I'll convene about what your plan is as far as additional evidence as I've discussed with you about that, at least from what you understand from me, prima facie needed in your initial presentation. If you're gonna supplement, how you're gonna supplement, when we'll get that.
Okay.
And then Attorney Green, I mean, I think that at that point, maybe a response from you. If you can make it joint, your presentation, your portion below, that makes it easier. If it's some different submissions, fine, but Attorney Green, you know what I mean, it's federal court, plaintiff's position, defendant's position type thing.
Okay. Need to do it by Thursday and I can figure out.
That's just as good with me. I don't care. If it has to be Monday, fine, but I mean, I want to have a sense of it. If we have to schedule things for September 16th, I want to get a sense of where this is going. So I mean. All right, I'm adjourning the meeting. Oh, sorry. I'm sorry. We need to open it.
We don't have to open it, we just have to table it till
Okay.
the 16th.
This doesn't concern the public, but I'm adjourning the 2 items for 65 Station Street. I'm adjourning them right now to September 16th, pending the submissions that I get from council. We'll take this matter up on the 16th. I'd like a motion for the last item, zoning regulation amendment for.
You should see all the bruises that are.
Hey, do I can just table it myself?
Yes, it's fine.
All right, so I am tabling third item of public comment for 1477 Congress Street LLC to what date?
September 16th.
September 16th as well.
Arranging that.
All right. So I'm adjourned. With that, I'm adjourning the hearing.
Recording stopped.